My
Yes.
I'm praying for listing in order, my lord.
Next week.
No, my lord, it is urgent, my lord,
What urgency?
because my Bakijaya process is going on, my lord.
When you want?
Then Tuesday or Wednesday, my lord.
Wednesday.
Obliged, my lord.
Rephrase your lordship. Lordship, I'm praying for listing of MSA appeal for orders. Matter is already amicably settled between the parties, lordship.
When do you want?
Wednesday, lordship.
Wednesday. Okay.
Obliged, lordship.
May I please, your lordship? With the concern of the others, and I beg to mention item number 60, my lord. Counsel for the petitioner every day is not well, so matter may adjourn for 2 weeks. Item number 60.
Heard, Mr. What is your name?
Disseminate.
DJ Medhi, Learned Counsel, sir. Submitting on behalf of Mr. A.B. De Learned Counsel for the applicant, who prays for an adjournment on the ground that the Learned Counsel for the applicant is not well. He submits that he has informed Learned Counsel for the respondent regarding his prayer for adjournment. The prayer is allowed. Let this matter be listed after 2 weeks.
Much of it.
May I please, Lordship, we file and IA in item number 20, Lordship. Please kindly call for the IA.
Call for the IA, item number 20. Ramesh, item number 20.
May I please, your lordship? I beg to mention number 32. Your lordship, kindly matter may be listed for hearing, your lordship. TCR is on record. Matter may be listed for hearing. Item number 32, your lordship.
Item number
32.
who is for the other side?
Other side, no, none was appeared. The other side till that. We have also issued notice as well as published on paper, your lordship. None was appeared.
We'll pass order when the matter is called.
May it please your lordship, I beg to mention listing of 2 MFA at the order column. For
Next week. Next
Any
week.
day.
No date fix. Next week to the date to be fixed by registry.
Much
May
of
I please, your lordship, item number 11. Kindly adjourn this matter today and also take the consent of other party. Item 11, your honor.
Item number 11. Have you informed the other side?
Take.
You have informed.
Yes, yes.
What is your name?
C. Bormon
You are appearing for?
and M. Doctor.
Heard Miss
C. Bormon.
C. Burman, Learned Counsel, appearing for Mr. N. M. Datta, Learned Counsel for the appellant, who prays for an adjournment on the ground of personal difficulty of the conducting counsel. She submits that she has informed Learned Counsel for the responding regarding her prayer for adjournment, who does not have any objection to same. Hence, the prayer is allowed. Let this matter be listed after 2 weeks on a date to be fixed by registry.
Your lordship, this MSc appeal was last listed on 2011-2024. We have some urgency. Lordship may give any date wish.
Or under what?
Order.
Next week,
Next week, any date, lordship?
Wednesday.
Wednesday.
Please, the lordship, praying for listing of a matter in hearing column, lordship.
Hearing, there will be no listing or mentioning. You pray before the registry, or we may list it in the orders column next week. In the orders column next week. You mention in the mention memo that it is to be listed in the orders column.
Please, lordship, I beg to mention MSc appeal on listing for listing.
In which column?
Lordship,
Which column?
no column for listing.
You take instruction and again. You take instruction and again mention at 2 p.m. Take proper instruction and mention at 2 p.m.
I'm sorry, lordship, next Wednesday, it seems, is a holiday.
Thursday.
Then Thursday. Yes.
Thursday.
Obliged.
This motion, yeah, item number 10.
Yeah, please, your lordship. Your lordship, this is second bail application, lordship. So notice me kindly, lordship, an updated record.
New ground has to be there, no?
On what ground you have?
If there is a contradiction among the testimonies of witnesses, lordship.
What is the matter? NDPS?
No, no.
POCSO.
Yes, sir. When I filed the first bail application, lordship, there were only 3 witnesses were examined, lordship.
3 witnesses
Yeah.
were examined.
Yeah, now it is lordship, 4 witnesses were already examined, 7 witnesses already examined, lordship.
Victim has been examined on.
Yes,
Okay. We issue notice. Heard Miss M.R. Devi, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor. This bail application under section 483 of BNSS has been filed by the petitioner Jahidur Rahman alias Jahidur Islam. Stop. His prayer for bail on earlier occasion was dismissed by this court. Let the notice be issued to respondent number 2. The petitioner shall take steps for issuance of notice in pursuant to the prevailing notification in this regard within 7 days from the date of the within 3 days from the date of this order, returnable when?
On 2nd of June, no?
On 2nd of June. Let also the scanned copy of the trial court record as well as scanned copy of the connected case diary be called for. Registry to take steps for requisitioning the scanned copy of the records. List accordingly.
Item
Number 40 and 41.
Notice is served.
Complete. On 14, lordship.
IA 1140. Yes, what is your case?
Yes, His Lordship, while the first bail application was pending before this Honorable Court Lordship, bail application number 2029 of 25, which was filed in the month of June 2025, Lordship, and the
Bail application number 20.
2029, Lordship.
Yes.
While this application was filed in the month of June 2025, and the informant, the applicant herein received the notice. She had filed her objection also in that bail application, which is item number 41, Lordship. Meanwhile, another bail application with the same applicant had filed that is bail application number 2401 of 2025, Lordship. While the other bail application was pending, the previous bail application was pending before this Honorable Court, Lordship, suppressing all the facts, Lordship. And in that particular case, Lordship, in the subsequent bail application,
Which one is the earlier one? 2029.
Yes, Lordship.
Subsequent was 2401.
2401.
Okay.
While the previous one was pending, an objection was filed by the informant. The second bail application was filed in the month of July, Lordship, and the same the accused there also the deponent is same in both the application. That is the father of the accused, Lordship. And the informant did not receive on the second bail application, did not receive the notice. Otherwise, before this bail application would have been allowed, she would have pointed out before this Honorable Court that the earlier bail application is pending. So an amicus was appointed by this Honorable Court, and my lord, the Honorable Court was pleased to grant him bail, Lordship. by order dated Lordship, by order dated 25/9/2025. Which is, that order also is annexed, Lordship. Is annexure 1, page 11, Lordship.
Yes.
And Lordship, I have also the case summary of both the cases, Lordship. I have annexed as annexure 3, Lordship. Page 16.
Yes.
Which is the alia bail application. And date of filing is 17/6/2025. And the second is annexure 4, the second bail application wherein the present IA is moved, Lordship, is 22/7/2025, Lordship. It's page 18, Lordship.
Now, where is the requirement that it should be mentioned? There is a notification.
Yes, Lordship.
Where is that notification?
Notification I have annexed, Lordship. Page 22, Lordship. With the same FIR, Lordship.
Where is that? In 22, where is that clause?
In case of subsequent
Which para?
3,
Clause.
3, Lordship.
Yes.
Same FIR, rejection. Same judge, but he has not mentioned because that bail application was pending, same FIR, Lordship.
Okay. So what is the prayer?
And he is stalking the victim, Lordship.
Stalking.
Yes, her movements, everything he is noticing and wherever he is following, Lordship. That I have mentioned in paragraph 8, Lordship.
Where is the proof of delivery of notice?
114, Lordship. 82.
What is the IA number in this?
IA number is 1140, Lordship.
No, but this is not the, give it to her. You go through the notice. Is it the compliance? Notice of this interlocutory application has to be given.
Yes, Lordship.
There is no mention about this interlocutory application. Because consequences will be grave. If notice is served, we will cancel the bail. Notice
No,
to
notice is not served, Lordship.
notice to
Notice is
Abdul.
not served. I have seen notice is not,
Mr. Das,
this is not. served.
you have to take steps for service of notice on Abdul.
Abdul,
Next step, Lordship, I will then, so OC, we will give it to Lordship, the accused person.
Will you take fresh steps?
Lordship, they will.
take the rest of.
Heard Ms. D. Ghosh, learned counsel for the applicant. Also heard Mr. K.K. Das, learned additional public prosecutor, who produces and a correspondence in support of his submission that notice to respondent number 2 has been duly served. However, on perusal of the said correspondence, it appears that there is no mention about the instant interlocutory application in the said correspondence. Neither it reflects that same was served on Abdul Ali, that is respondent number 2. The petitioner is directed to take fresh steps for issuance of notice upon respondent number 2 Abdul Ali through the officer in charge of the jurisdictional police station. The notice shall be sent to the officer in charge of jurisdictional police station by the office of the public prosecutor. An additional public prosecutor is requested to ensure that before the next date fixed, the notice is duly served on the respondent number 2, and a report to that effect is also procured from the officer in charge of jurisdictional police station. Let this matter be listed again on 22nd June. Or you want short date?
Short date, Lordship.
17 June.
Can it be on 5th of June, Lordship? I'll take step during the course of that.
5th of June. List accordingly.
Deep.
Item 12. My lord, this is a miscellaneous appeal, my lord, guardian appeal, my lord. On the basis of the report, without satisfaction of the mediation report, case has been closed in absence of me, my lord.
The matter was settled.
Not settled. Though in mediation, there was a settlement, but subsequently, no settlement took place. But the case has closed on 11/3/2026, page 57.
Who are you?
I am the father.
The child is with mother.
Mother.
Okay, we'll issue notice.
Yes.
Heard Mr. S.K. Ghosh, learned counsel for the appellant. This appeal under section 47 of the Guardianship and Wards Act 1890 has been filed by the appellant Chanchal Goswami, impugning the order dated 11/3/2026 passed by the Principal Judge, Family Court in FC within bracket GA, case number 21/2023. Stop. Issue notice to the respondent and call for the records of the aforesaid case from the family court. Family court Kamrup,
Kachar.
family court Kachar. The registry shall take steps for requisitioning the records. The appellant shall take steps for issuance of notice to the respondent by speed post as well as by usual mode within 7 days from the date of this order, returnable on.
My lord, regarding usual process, my lord, it is outside the state.
Usual process means it will be sent to that
Respective.
jurisdictional court. You take steps by usual process, registry will send, there is a mode.
Acha.
Let this matter be listed again on 13th of July.
Item number 14, lordship.
Item number 14.
40, lordship, the
My lord,
accused
just now he has come, my lord. And
Abdul
I
Jalil.
have seen in the board rule that 40, immediately I have run now.
What is your submission?
My lord, I asked him, then he replied that the father of the Abdul, that is accused, my lord, accused was in jail, my lord. And brief was given the session court's lawyer, my lord. And they were, my lord,
No, but there is a violation of.
yes, my lord. That's
So bail is liable to be cancelled.
what happened, my lord? The advocate of the London trial court, who is represented on behalf of the accused party.
Okay, we'll take it up at 2. But I am inclined to cancel the bail. You convince me why it should not be done
That's right.
at 2.
Deponent is same lordship.
Yes.
The father is the deponent.
We will decide at,
both
we'll
cases.
decide at 2.
He said that my father did not aware whether bail is pending in the High Court because he did not.
Not now at 2.
Deeply aware.
Item 13.
May I please, your lordship? Lordship, my senior is now appearing in another court. Therefore, I'm humbly praying for a timely this matter.
You have interim prayer. Let him come.
Much obliged.
Item 14.
My lord, this is a statutory appeal. Make the lordship. Here, my lord, I've changed an order. Whereby, my lord, under order 7 rules 11 D, my lord, my plaint was rejected.
Plaint was rejected.
Yes. On the ground that, my lord, they use an alternative remedy under section 34 of the Surface Act. Fact remains, my lord, here fraud and misrepresentation was specifically pleaded in the case. And I'll what you will find the impute order at page 119.
Where is the error in the?
Your lordship, what has happened, my lord? I'll just take you to the pleadings which has been reflected, my lord.
It was held to be barred by section 34.
34. But, my lord, here specific allegations of fraud were there. I'll just take you to on page 150, my lord, of the that is the plaint. Now, what had happened, my lord? My lord, here the appellants, my lord, they took a loan. And in fact, my lord, without, my lord, any application for restructuring, the husband of the appellant number 1, he expired long back. My lord. His signatures, my lord, on a date that is on, my lord, the loan account became NPO 38 to 90, 2021.
Okay.
30,
Okay, we are issuing notice. We are not admitting the appeal now. After the appearance of heard Mr. R. D. Learned Counsel for the appellant, this appeal under section 96 of the Code of Civil Procedure 1908 has been preferred by the appellants, impugning the order dated 16/12/2025, passed in Ms. J case number 223/2024, arising out of title suit number 55/2024 by the Court of London. Which court?
Civil judgment.
By the Court of London, Civil Judge Senior Division, Nagaon, rejecting the plaint of the present appellant under Order 7 Rule 11 within brackets small d of the Code of Civil Procedure 1908, holding therein that the suit of the present appellant is barred by Section 34 of the SURFACE Act 2002 to issue notice to the respondents. The appellant shall take steps for issuance of notice upon the respondent by speed post as well as by usual mode within 7 days from the date of this order, returnable on
27 July.
27 July, list accordingly.
Item 16.
May I please consider this appeal is filed against the order dated 13/3/2026 passed by the London Assistant Labour Commission in the Commissioner. Impugn order is at page 81. The relevant portion is at page 88, Lordship.
What is the substantial question?
Actually, the Lordship, here we have not given any opportunity. Just kindly see the order sheet, page number 67.
No, where is this?
No, there is no employee-employer relationship because the other day.
Where have you mentioned the substantial question?
I just said.
Employees compensation act.
Lordship, kindly turn up to page 66. 67.
Page?
67. The order sheet, kindly, Lordship.
Oh, in your memo of appeal, where is the mention?
Your Lordship, the substantial question of law involved that is whether there is a employee-employer relationship is exist or not.
How that can be a question?
No, because I was not given any opportunity to hurt because only the claimant's evidence was taken. Thereafter, kindly see the that's why Lordship, I'm telling you. Kindly see the page
No,
66.
no. Where have you mentioned the substantial question of law involved in your memo of appeal? Show me that. Or you can specifically mention it. I am giving you time. You take time. Heard Miss J. Paul, learned counsel for the appellant, who prays for some time to amend the memo of appeal to specifically mention in the same the substantial question of law involved in this appeal. The prayer is allowed. Let this matter be listed after a week on a date to be fixed.
After 2 weeks, sir.
After 2 weeks on a date to be fixed by the district. Also show the presence of Mr. T.R. Gogoi, London, Government Counsel appearing for respondent.
1, 2, 3, and 4.
1, 2, 3, and 4.
Plus.
Item 17.
May it please your Lordship. Your Lordship, this present appeal has been filed under Section 23 of the Railway Claims Tribunal Act of 1987, challenging the impugned judgment passed by the RCT on order dated
Mr. What is your name?
A. Dev.
A. Deb, learned counsel for the appellant. Also, this R. Devi, learned Central Government Council appearing for the respondent. This appeal under Section 23 of the Railway Claims Tribunal Act 1987 has been preferred by the appellant Messrs. Jain and Jain Company Limited, impugning the judgment and order dated 19/2/2026 passed by the Railway Claims Tribunal Gauhati in OA number Roman 1-07/2018.
Your lordship, there is a clerical mistake. The judgment was passed on 16/2/2026. There has been a
Passed on 16 instead of 19 to 16. You rectify this.
yes, your lordship.
Stop. Learned counsel for the appellant praise for allowing the appellant to rectify the clerical mistake, some clerical mistake which has crept in the cause title of the memo of appeal. Prayer is allowed. The appellant shall file a corrected cause title of the memo of appeal before the next date fix. Let the records of the OA 1/07/2018 be called for from the Railway Claims Tribunal Gauhati Registry to take steps for requisitioning the records. List this matter after receipt of the records on 24th of June.
Much obliged.
Item 18. Dear Lordship, my lord, this appeal we have filed. My lord, this is a statutory appeal. We have filed it as.
Your claim was dismissed or
My lord, very low amount has been awarded for.
for enhancement?
For enhancement we have filed.
Heard Mr. J. Mullah, learned counsel for the appellant. This appeal under Section 173 of the Motor Vehicle Act has been preferred by the appellant, namely Muhammad Abdul Sattar, impugning the judgment and award dated 5/12/2025, passed by the Motor Accident Claims Tribunal number 3, Kamrup Metro, in MAC case number 1124/2022. The appellant is basically aggrieved with the quantum of compensation awarded to him. Stop. After going through the grounds stated in the memo of appeal, this appeal is admitted. Let the records of MAC case number 1124/2022 be called for from the concerned tribunal. The appellant shall take the registry shall take steps for requisitioning the records. Let also notice be issued to the respondents. The appellant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 13 July.
Item 19.
This is your lordship. Lordship, this statutory appeal is filed because of violation of policy condition, lordship, and on quantum also.
Heard Ms. R.D. Majumdar, learned counsel for the appellant. This appeal under Section 173 of Motor Vehicles Act has been preferred by the Oriental Insurance Company Limited, impugning the judgment and award dated 5/2/2026, passed by the Motor Accident Claims Tribunal number 2, Kamrup Metro, in MAC case number 149/2023. I have perused the grounds stated in the memo of appeal, as well as considered the submissions made by learned counsel for both sides and learned counsel for the appellant. This appeal is admitted. Let the records of MAC case number 149/2023 be called for from the concerned tribunal. Let also notice be issued to the respondents. The appellant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on
20 of July.
20 July.
Hello. State petition, Lordship, let it
Let,
be.
let them appear.
Like,
Item 20.
Make me the lordship. My lord, sorry lordship, that was not in the list, lord, IA lordship. My junior was paid for take up the matter lordship for along with my statutory appeal lordship. There is a glaring defect lordship, that the vehicle which was mentioned,
Is there any IA?
IA is their lordship. IA is their lordship. IA,
You have not given mention memo.
sorry lordship, actually, he has put out lordship for which he has been given the slip lordship. I think that's not there. He has given a slip lordship for which your lordship was allowed to call the
What is your grievance in the appeal?
appeal is lordship, the offending vehicle lordship. There is a glaring defects lordship, the vehicle
Who are you? You are the claimant.
and for the lordship owner lordship.
Owner. You were directed to pay.
Lordship. So lordship, for which I filed this appeal lordship, because as per page judgment, page 58 lordship, may kindly peruse lordship. Lordship, the learned court below has vehicle that which occurred the accident lordship, in his evidence lordship, is a different vehicle, not my vehicle lordship. Actually, what has happened lordship, on that day, while they were approaching the present driver lordship to take up the hospital lordship, he has told that he has some problems to go for other lordship passengers for which, and ultimately he was making as a lordship all the offending vehicle. But in his evidence lordship, the claimant denied the vehicle, my vehicle number lordship. In his judgment also, learned court below has categorically mentioned in page 58 lordship, or so and so, and as such his admission that one Bolero vehicle number so and so was offending vehicle is although a glaring defects in the claimant case lordship. So once the glaring defects are there lordship regarding the identification of the vehicle lordship, for lordship, I am the victim of harassment, nothing more than that lordship. And the criminal case also lordship, it was closed lordship, he has not contested in the criminal case also.
No, your submission is that your vehicle was not involved in the accident.
Lordship, that is my.
Is there any evidence?
Lordship.
Okay.
Evidence.
Heard Mr. K. A. Majumdar, learned counsel for the appellant. This appeal under section 173 of Motor Vehicles Act 1988 has been preferred by the appellant, namely Karimuddin, who is the owner of the, who has been directed to pay the compensation. No.
No, Karimuddin is the claimant lordship. I am the Muslima Khatun lordship and the driver lordship. Karimuddin, Muslima Begum lordship.
Filed by the appellants, namely Muslima Begum Laskar and Zakir Hussain Laskar, impugning the judgment and award dated 1/4/2026, passed by the Motor Accident Claims Tribunal Kachar in MAC case number 288/2020. I have gone through the grounds of appeal stated in the memo of appeal. and have considered the submissions made by learned counsel for the appellants. This appeal is admitted. Let the records of MSC case number 288/2020 be called for from the concerned tribunal registry to take steps for requisitioning the records. Let also the notice be issued to the there is no insurance company.
No, Lordship. Only.
Notice be issued to the respondent. The appellants shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on
22nd of July.
22nd July.
Till then, Lordship, the impugned order may be stayed, Lordship.
We are issuing notice in is whether any execution case has been filed.
Not yet, but order is there within 1 month, Lordship, for which I filed this petition, Lordship. There is
But execution case has not yet been filed. We are issuing notice.
till return, I pray, Lordship, till
No,
return.
no. Issue notice in, give a short date. Last of July, June,
26.
26 June,
26 June.
June.
Item 21.
Much obliged, Lordship.
Your Lordship, kindly pass over the matter for time being. My senior is in another court.
What is the matter?
There is a limitation of 90 days, but there is no delay.
We'll issue notice.
Let him come.
Heard Ms. D. Goswami, learned counsel for the appellant. This appeal under section 173 of Motor Vehicles Act has been preferred by the appellant Bajaj Alliance General Insurance Company Limited, impugning the judgment and award dated 28/1/2026 passed by the Motor Accident Claims Tribunal Golaghat in MSC case number 132/2016. Directing the appellants to pay a compensation amount of rupees 6,82,301 along with the interest to the claimants respondents. I have gone through the memo of appeal as well as considered the submissions made by learned counsel for the appellant. This appeal is admitted. Let the notice be issued to the respondents and let the records of MSC case number 132/2016 be called for from the concerned tribunal registry to take steps for requisitioning the records. Appellant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on
22nd of July.
22nd July. In IA also issue notice.
Obliged.
Item 22.
Wait, please, Lordship. Here in this case, I am appearing on behalf of Mr. D. Mondal. Lordship. Appeal is against dismissal of claim petition.
Claim was dismissed.
Lordship.
Heard Mr. M. Talukdar appearing on behalf of Mr. D. Mondal, learned counsel for the appellant. Also admits, what is your name?
K. Borpujari.
K. Borpujari appearing for
Yes, Lordship.
respondent number 1. This appeal under section 173 of Motor Vehicles Act 1988 has been preferred by the appellant Praveen Chandra Das alias Praveen Das, impugning the judgment and order dated 2/3/2026 passed by the Motor Accident Claims Tribunal number 2, Kamrup Metro in MAC case number 1595/2022, whereby the claim case filed by the present appellant was dismissed. I have gone through the grounds taken by the appellant in the memo of appeal and have considered the submissions made by learned counsel for the appellant. This appeal is admitted. Let the records of MAC case number 1595/2022 be called for from the concerned tribunal and registry to take steps for requisitioning the records. Let also notice be issued to the respondent. The appellant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order.
One entire appearance.
Returnable on 13 July. Since Miss Barpujari has already appeared for respondent number 1, no formal notice need to be issued for respondent number 1. You have received the memo of appeal. The appellant shall furnish a copy of memo of appeal along with annexures to the learned counsel for respondent number 1. List accordingly.
Right.
Article 23.
Yes.
Please, Your Lord. We have filed the appeal under section 173 MBA for dismissing of our claim petition on the ground of want of territorial jurisdiction.
Claim was dismissed.
Lord.
Heard, Mr. What was the error?
Taken up this matter for final disposal even by remanding the matter back for return of the claim petition for filing in appropriate jurisdiction, Lordship, if Lordship considers this, Lord. Because no issue was framed, if Lordship goes to page 27. No issue was framed on any jurisdiction, no challenge was made by the insurance company or by the owner.
No, you can still file the.
I have not mentioned my temporary address, though I am a resident temporarily residing at district Barpeta. I am a permanent resident of district Pajali. In filing claim petition, inadvertently that was not mentioned.
No. At this stage, let us issue notice. Let the other side come.
Lordship.
Heard Mr. S.K. Poddar, learned counsel for the appellant. This appeal under section 173 of the Motor Vehicle Act 1988 has been preferred by the appellants, impugning the judgment and order dated 20/2/2026 passed by the Motor Accident Claims Tribunal Barpeta in MAC case number 377/2021, whereby the claim case filed by the present appellant was dismissed on the point of territorial jurisdiction. Stop. I have gone through the grounds stated in the memo of appeal. Let the notice be issued to. Whether records would be necessary. Let the notice be issued to respondent. The appellant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on
20 July.
20 July.
Okay.
List.
Okay. Item 24.
May I please? The statutory appeal by the insurance company, is it?
Heard Mr. P. Hajorika, learned counsel for the appellant insurance company. This appeal under section 173 of the Motor Vehicles Act 1988 has been preferred by the appellant insurance company, appellant Messrs. Shriram General Insurance Company Limited, impugning the judgment and award dated 17/2/2026 passed by the Motor Accident Claims Tribunal Nalbari in MSC case number 61/2019, whereby the appellant was directed to pay a compensation award of 18,16,661 along with interest to the respondents claimant. I have gone, what ground you are,
Actually, this is the disputed claim, my lord. The person fallen from tree, my lord. His son admitted in the hospital stating that he got injury from due to fallen from tree. After 24 days of treatment, he died, my lord. Thereafter, after 1 month, FIR is lost.
I have gone through the grounds stated in the memo of appeal and have considered the submissions made by learned counsel for the appellant. This appeal is admitted. Let the records of MSC case number 61/2019 be called for from the concerned tribunal. Let also notice be issued. The appellant shall take steps for issuance of notice upon the respondents by speed post,
Both ways.
as well as by usual mode, within 7 days from the date of this order, returnable
29th
on 29th of July,
My lord.
list accordingly.
So then, IA for the
We'll issue notice.
considering the nature of the case, some protection, my lord, because that
Is there any execution case filed?
1 month time was granted. I'll have to take instruction, but 1 month time.
Deposit 50%.
But some observation regarding release, my lord, they may not be allowed to release. At least.
No, let notice be issued. Give a short date. In I also not issue
My lord.
notice.
Same day.
Same day,
The same day.
22nd June.
Supplementary item
Public.
63.
In this matter, my lord, I am not submitting on merit. Both the parties, my lord, they have agreed to mutually settle the matter, my lord.
Who is for the other side?
SS Goswami, my lord. But before that, I have to say one thing, my lord. In this matter, my lord, the impugn order was passed by your lordship, my lord. So, lordship.
Who is None has appeared for the appellant on call. Let this matter be listed in the after a week on a date to be fixed by registry.
Orders item 25.
May I please, Your Lord? Some time is needed, my lord. We have sent the paper for his signature, my lord.
Not miss. Paper publication against.
Substitution, my lord.
Substitute.
Oh,
Legal heirs, my lord.
heard Miss L. Sharma, learned counsel for the appellant. Who died?
Gender.
This is
Respondent number?
1, my lord.
Oh, Mr. Das, for whom you are appealing?
Rajan Das, my lord.
Deceased.
Rajan Das, already died, my lord. He is declared to be substituted now.
Also, learned counsel for respondent number 1. Learned counsel for the appellant seeks some time for taking steps for substituting the legal heirs of the deceased respondent number 1. The prayer is allowed. How much time?
3 weeks.
Let this matter be listed after 3 weeks on a date to be fixed by registry.
Pleasure.
26.
My lord, here, my lord, Elsa received, my lord. 1, 2, 3 appeared, my lord. We have to take fresh steps on respond number 4 and 5.
Heard Miss L. Sharma, learned counsel for the appellant. Also heard Mr. A. Khan appearing for respondent number 1, 2, 3. Learned counsel for the appellant seeks some more time to take steps for issuance of notice upon respondent number 4 and 5. The prayer is allowed. The appellant shall take steps for issuance of notice upon respondent number 4 and 5 within 7 days, within 15 days of the date of this order, returnable on
20 July.
20 July.
Oh, bless you.
Item number 27.
Make the lordship. Lordship, the present application has been filed praying for restoration of the appeal. which was dismissed for-
Restoration.
Lordship, dismissed for default, lordship. I have annexed the order at annexure A, relevant portion at page 9.
Yes.
Lordship, only thing is that, Lordship, the original case was of, they have not mentioned, Lordship. Appeal was of 2012.
Yeah.
And the original case was of 2008, Lordship. MSC case number 1 of 2008. Now we are in 26, Lordship. So, Lordship, what about the interest? It is their own, they have.
This case is for enhancement.
Surely claimant has filed.
No, sometime their case when it is
Dismissed.
dismissed.
I do not have the memo of appeal, Lordship, and in
Enhancement.
earlier round I was not
For
there.
enhancement.
When have you filed the restoration petition?
Restoration petition was filed, lordship. After 69 days, on 2/10/2018. There was some delay of.
Then why it is listed after so many?
There was a delay.
There was a delay also, Lordship. That
How much delay?
69 days, person. 69 days only.
Now, what are the reasons?
It's only for the negligence of the
Council,
Alia council.
then it is not. Then can that be a valid ground?
no.
That too of a. Where is the reasons?
Lordship reasons has been explained at page 4, paragraph 8 to 12, Lordship. Lordship, no, Lordship, paragraph from paragraph 4 to 12, Lordship.
Yes, Ms. Majumdar.
Lordship, for the fault of the council, claimant should not be supported.
Lordship, that is settled on that council. If they are saying that, the council should be made a party behind the back of somebody.
Let the council pay the cost in thousands to the insurance company.
Yes,
Otherwise, council will continue to commit lapse.
but Lordship, how do we know that the council committed any lapse? They are changing the council. They are bringing another council so that they can allege the other council that he was at the fault. Lordship, the best would have been the same council continuing the year. Then we could have said that he could have even stated why he defaulted. But now they are changing the council and alleging that that other council made the mistake, Lordship, and he's not made a party. At his back, they are making those allegations.
Read Order 41, Rule 19. Order 41, Rule 19. If it is proved that he was prevented by any sufficient cause, you show authorities in support of your submission.
I am leaving to Lordship.
No, otherwise I will dismiss it.
Lordship, kindly consider the, normally the restoration petition is allowed. And for the fault of the council, the claimant should not be suffered. At least the interest portion for the delay period.
We'll take it up in the second half. You come up with the authorities that in such cases, lapse of council may be condoned under Order 41, Rule 19.
Let the matter be listed on some other day.
Lord Mr. M. Talukdar, learned counsel for the applicant, also heard Miss R.D. Majumdar, learned counsel for respondent
One.
number 1. No. Respondent number respondent Mrs.
Sole respondent.
Oriental Insurance Company Limited. This interlocutory application has been filed by the applicant praying for restoration of MSC appeal number 40/2012.
140.
140 or 40? 40/2012, which was dismissed for default by order dated 23/7/2018. The learned counsel for the applicant submits that due to lapse on the part of the earlier engaged counsel, the applicant could not be represented before the court when the connected appeal was called on for hearing on 23/7/2018. When a pointed query was posed by the court as to whether same can be regarded as a sufficient cause which prevented the appellant from appearing before the court when the matter was called on for hearing under Order 41, Rule 19 of the Code of Civil Procedure, the learned counsel for the applicant prayed for some time to produce some authorities in support of his submissions. The prayer is allowed. Let this matter be listed
June.
on 22nd June.
Item number 28 and 29.
Yes.
Office note dated 14/5/2026.
Respondent number 2. What will you do?
Registered post is returned back, but usual post which was served through the civils as Bogota, Junior Division, that was not a return or served. That's why service is awaited.
So what should we do?
After 2 weeks,
Heard Mr. A. Hussain, learned counsel for the appellants. Also heard Mr. R. Sharma, S. Sharma,
Appearing for respondent number 3.
learned counsel for learned counsel appearing for respondent number 3.
Behalf of A. Acharya.
On behalf of Mr.
A. Acharya.
A. Acharya, learned counsel for respondent number 3. On perusal of the office note dated 14/5/2026, it appears that notice issued to respondent number 3, respondent number 2 by speed post has returned When have we taken steps for?
on 17th of March 2026.
Returned with a report that no such person in the address returned to sender. However, learned counsel for the appellant submits that notices, service report in respect of notices which were sent to respondent number 2 by usual mode has not yet arrived, and therefore he prays for awaiting the service report. The prayer is allowed. Let this matter be listed after 2 weeks. Oh. 22nd June.
Item number 30.
Wait, please, Your Lordship. Your Lordship, service may be awaited on respondent number 2.
Heard Mr. S. Datta, learned counsel for the appellant. Also heard Miss Imbora, appearing on behalf of Mr. S.V. Chaudhary, learned counsel for respondent number 1. Service report in respect of respondent number 2 has not yet been received. The registry is directed to place the postal track consignment report of notice issued to respondent number 2 by speed post before this court on the next date fixed. Let this matter be listed on 24th of June.
What's okay? Item 31.
Please, my lord, this appeal is against an award for announcement of compensation granted to the appellant. Now, the other side has come, the lower court record has also is also there, my lord. I pray for this still.
Mr. S. Chakravarti, learned counsel for the appellant. Also, Ms. L. Sharma, appearing for respondent number 2. It appears that service of notice on all the respondents is complete in this case, and the records of the concerned motor accident claims tribunal have also been received. Hence, this appeal is ready for hearing. Let this matter be listed for hearing. Hearing at the date of 25th August.
Item number 32. May it please your lordship. Lordship, I'm appearing for the respondent. Respondent has passed away, your lordship, on 2022, 13/4/2022.
How many sole respondent?
Yes, sir.
Yes.
Your lordship, kindly peruse the order dated 10/2/2026 in I.
ISM. What order? Yes. No, but now respondent has passed away. You have to take steps for substituting. You take steps for substituting the legal heirs. Heard, Mr. What is your name?
A Pator on behalf of Jay Sharma.
A. Pator,
On behalf of Jay Sharma.
appearing on behalf of Mr. J. Sharma, learned counsel for the appellant. Also heard, Mr. What is your name?
You Bharadwaj, your lordship.
U. Bharadwaj, learned counsel for the respondent, who submits that the respondent has expired on which date?
13/4/2022, your lordship.
On 13/4/2022. And to support his submission, he has produced a copy of death certificate of the respondent issued by the Department of Health and Family Welfare, Government of Assam. The said certificate is marked as X and kept in the records as a part of the record. Stop. In view of the submissions made by learned counsel for the respondent, learned counsel for the appellant seeks some time to take appropriate steps for substituting the legal heirs of the deceased respondent. The prayer is allowed. Let this matter be listed after 2 weeks on a date to be fixed by registry.
Lordship, please. Item number 33.
Should we kindly peruse the order dated 1st April 2026?
Yes.
The case records went missing and then this order was passed.
Okay. Then what happened? Okay. None appears for the appellant on call. Mr. A. Dhar, learned counsel for the sole respondent, is present. It appears that by order dated 1/4/2026, the trial court was directed to send the trial court records in whatever conditions it is available there. However, it appears from the office note dated 15/5/2026 that no such record has yet been received. Stop. Issue reminder to the trial court. Let a copy of order dated 1/4/2026, along with the instant order, be also sent, along with the reminder to be sent to the trial court. Let this matter be listed
26th of June.
on 26th of June.
Item number 34.
May please your lordship.
The binding matters are sending. Yes,
Lordship, as per office note dated 15/5/26, Lordship, respondent number 2, the service could not be served, Lordship. And respondent number 3 has not yet received back. So we want to take steps upon respondent number 2 by Dusty. And respondent number 3 may be awaited, Lordship.
Or maybe allowed to through the local police station because it's a long pending in case since 2022.
Dusty will be more appropriate, Lordship. Because
In a both way, in a both way.
in
The-
police station, where is the provision? In civil matters. Show me the provision. Heard,
Because
Yes.
address is of Kamrup.
heard Mr. SP Sharma, learned counsel for the appellant. Also heard Mr. R. Pator,
D. Kapoti.
D. Kakoti, learned counsel for respondent number 1. On perusal of the office note dated 15/5/2026, it appears that the notice issued to respondent number 2. Who is respondent number 2?
The owner, Lordship.
Honor.
And 3 is the driver. The
Will
three
not be
service-
served. Whereas notice issued to respondent number 3 has not yet returned. Learned counsel for the appellant submits that since the respondent number 2 owner is the resident of Kamrup district, Metro District, the appellant may be allowed to take steps on the said respondent by way of dusty mode. The prayer is allowed. The appellant shall take steps for issuance of notice on respondent number 2
Three,
by
Lordship. Or 2, Lordship.
2 by dusty mode within say 15 days from the date of this order, returnable on
13th of July.
13 July. The registry is directed to place the postal track consignment report of notice sent to respondent number 3 before this court on the next date fixed. In the event the appellant is able to serve the notice on respondent number 2 by dusty mode, it shall file an affidavit in compliance thereto on the next date fixed, list accordingly.
Once of this.
Yes.
I have taken the steps on 9/3/26.
Heard Mr. R. Goswami, learned counsel for the appellant. Also heard Mr. A. J. Swaikya, appearing for respondent number 5, as well as Miss R. Gogoi, appearing for respondent number 1. On perusal of the office note dated 16/2/2026, it appears that the notice issued to respondent number 4 has been duly served. However, the notice issued to respondent number 3 has not yet returned. You have to take fresh steps.
May be track of for one reason. Now the issue is between New India and United India, two insurers. Because what is in the earlier analogous cases,
Who is the claimant?
claimant is respondent number 1. My main ground of challenge in this case that earlier analogous cases have been decided against New India. The finding of fact was that this is a vehicle that was responsible for ration negligence. But in this case, suddenly after recording everything correctly, the name of the who is responsible, then United India was missed. This is my. Otherwise, factually, that part is correct. It came to a finding of fact that accident occurred due to a ration negligence of the struct. But when it came to giving that inference lordship, it was United India which ought to have been New India. So owner driver they may not be required loss. That will always
Do you have
prolong the
anything
year.
to,
It's a short issue.
any submission?
Lordship, only this case I am appearing lordship for the New India. So other cases, state lordship, I have no instruction. Lordship.
Then counsel for the appellant submits that since the issue involved in this appeal is regarding the liability, regarding a decision as regards the liability of paying the compensation between the present appellant as well as respondent number 5. Hence, he submits that presence of the driver and owner, presence of 3 is the owner of the truck bearing registration number AS01H5336 is not necessary for adjudicating the present appeal. Hence, he prays for waiving the notice to the said respondent. The prayer is allowed.
Also 2 lordship, 3 are driver and 4 is sub driver.
Who has been represented by filing Wakalatnama. Only 3, service on 3 is remaining. Records have arrived.
Then because it may fix for a hearing also.
As the records,
Because stay has not been granted.
records of the trial court have been received. This matter is ready for hearing. Let this matter be listed for hearing.
That's it, because I have not got I asked for a stay here. I've asked for a stay, which has not been allowed. Because
After 4 weeks on a date to be fixed
yes,
by
that's
registry.
right. 4 weeks.
Item number 36.
None has appeared for the appellant on call. So it appears that by order dated 6/5/2026, the registry was directed to place the interlocutory application filed by the appellant along with this appeal. However, same has not been done. Registry is directed to comply with the directions given in order dated 6/5/2026. Let this matter be listed after 2 weeks on a date to be fixed by ministry.
Item number 37.
Please, your lordship. Lordship, I am on behalf of respondent number 2. We will receive the, we have received the notice and we will file wakalatnama.
Who is for one?
I am for R1. And as for office note, TC has not been received back and unserved notice has been returned under R3, your lordship, addressing them. It's a flag A, your lordship may kindly have a look at the office note dated 15/5/2026. So they need to take fresh steps on arbitrage.
Order number 3. You take fresh steps.
Lordship, respondent 2 and 3, 2 is the proprietor of proprietor of R&D. Same respondent. They are services the company.
So you are appearing for.
Respondent 2 and 3.
Okay.
May send reminder to the learned trial court.
Okay. Miss, what is your name?
Here go.
K. Gogoi. Appearing on behalf of the
PV Waterford.
PP Bhattakur Learned Counsel for the appellant. Also Miss B. M. Bhuya. B. Bhuya, Learned Senior Counsel appearing, assisted by Miss P. Kashyap, Learned Counsel for respondent number 1. Also Miss D. Pathak appearing for respondent number 2 and 3. Service of notice on all respondents is complete. However, it appears that records of the trial court have not yet been received. Registry to issue reminder for the same and list this matter again after 3 weeks on receipt of the trial court records.
Shall name be shown in the cause list?
Name of Miss.
SC/BTC will do, your lordship.
Name of Standing Counsel BTC be reflected in the cause list as engaged counsel for respondent number 1 henceforth.
Lordship, my name will be.
Name of Miss B. Pathak may also be reflected as engaged counsel for respondent number 2 and 3 in the cause list henceforth. Please second.
Number 38. May I please be lordship? According to office note dated 14/5/26, AD card of respondent number 2 has not been returned back. Also, the postal tracking record has been deleted from the system. And the LCR is received.
Then you have to take fresh steps. What do you suggest, respondent number 2?
Sir, I suggest that the respondent number 2, who is the owner, his name may be struck off.
Why?
Because in lower court also he has not contested the case.
Ex parte.
Yes.
Okay. Heard Mr. A. Agarwal, Learned Counsel, A. Agarwal, Learned Counsel for the appellant. On perusal of the office note dated 4/5/2026, 14/5/2026, it appears that the notice issued to respondent number 2 has not yet been received back. It also appears that due to lapse of time, the data due to lapse of time, the postal track consignment report also is not available in the website of the speed post, website of the postal department. Learned Counsel for the appellant submits that respondent number 2, who is the owner?
Yes.
Who is the owner of the offending vehicle, also did not appear before the Motor Accident Claims Tribunal, and the inquiry proceeded ex parte against him. Hence, he prays for waiving the notice in this appeal also. The prayer is allowed.
Lordship, this case is for enhancement of compensation. Since LCR is also received, it may be fixed for hearing.
Since the service of notice on all the, since the records of the concerned MAC case have already been received, this matter is ready for hearing. Let this matter be listed for hearing. 27th of August.
Item 39.
May I please, your Lordship? Lordship, in this case, as per the office note, Lordship, for 14/5/2026, Lordship, the notice upon the respondent number 1, Lordship, returned with unsafe, unserved, and also reflected that Lordship, respondent number 1 has refused to accept the notice, Lordship.
Okay, then we'll deem this is for enhancement.
Lordship, on, not for enhancement, only the point to be decided by this honorable court is that whether the policy obtained by the owner of the vehicle is an Lordship comprehensive policy or it was an Lordship act policy. Lordship, as per the judgment reflected passed by this Lordship learned member, it was a comprehensive policy. If it is a comprehensive policy, then Lordship, the pillion rider is also covered under the comprehensive policy, Lordship.
Okay. Heard, Mr. Your appeal was dismissed. Your claim was dismissed.
No, Lordship, actually what happened, he is the owner of the offending vehicle, your Lordship. He has prepared the appeal. And
Heard, Mr.
this
B.
survives.
Sharma, learned counsel for the appellant. Also heard Mr. S.I. Akan,
For the respondent number 3.
appearing for respondent number 3. Who is appearing for 2?
The name has been shown, but his name has not been shown in the first list, your Lordship. My name also not.
It appears that though a direction was given by the last order, that is order dated 2/4/2026, to reflect the name of Mr. T. Kalita as counsel for respondent number 2, as well as name of Mr. S.I. Akand as counsel for respondent number 3. Same has not been done. Registry is directed to comply with the directions issued to it by order dated 2/4/2026. Stop. On perusal of the office note dated 14/5/2026, it appears that notices issued to respondent number 1 has been received back with a postal endorsement within inverted comma, refused to accept inverted commas close. Since the addressee, that is respondent number 1, has refused to receive the notice, same is deemed to be duly served on him. The service on all respondents are therefore complete in this case. It also appears that the records of the motor accident claims case number 146/215 within bracket D has also been received. Hence, this matter is ready for hearing. Let this matter be listed for hearing
27 August.
on 27th August.
Highly. So much.
Item number 42.
May I please, Lordships? For, in this case, my lord, 396 days, my lord, 396 days, my lord. And I.
You are claimant or insurance company?
I'm claimant, my lord, for enhancement, my lord, in this case.
My lord, we
Only
have to file
34,000.
objection, my lord.
You have not filed objection.
We have to file.
And 2 in 3?
My lord, 2 and 3, my lord, 2 is my lord, the registered owner of the offending vehicle, my lord, and 3 is the driver of the offending vehicle, my lord.
Okay. Heard Mr. S. Ahmed, learned counsel for the applicant. Also heard Ms. L. Sharma, learned counsel for respondent number 1, who praised for some time for filing written objection against the prayer for condonation of delay made by the applicant. It also appears from office note dated 15/5/2026 that notice issued to respondent number 3 has been duly served. Stop. As regards respondent number 2 is concerned, the service report has not yet been received. The registry is directed to place the postal track consignment report of notice issued to respondent number 2 by speed post before this court on the next date fixed. Let this matter be listed on
24th of June.
24th of June.
My lord. Much obliged. Item number 43. Also, in this case, appeal is already admitted, Lordship. And in 2098, Lordship, their petition to stay the Bakida proceedings, Lordship, is extended from time to time till 11th of this month, it was there, Lordship. So they had filed one objection. Now, what objection do you want to say, Lordship?
Yes, where is the objection?
Your lordship, we have filed it.
You have filed.
Yes.
Yes, they have filed.
What is your submission?
Lordship, I'm just a proxy counsel appearing on behalf of the engaged counsel. Yes, my lord.
Other on also, they have time, took time, Lordship. So this is a statutory appeal, Lordship. It is already admitted, Lordship. So we want to deposit, Lordship, 50%, and subject to that, Lordship, full listing may be granted in the warrant of arrest, Lordship.
What is the amount?
Lordship, 2,07,500, Lordship.
What is your ground here in this appeal?
Lordship, in appeal, Lordship, our grounded, there are two vehicles are involved in this accident. The victim was driving the non-offending vehicle, and non-offending vehicle was insured with us. So as per their deposition, the accident took place due to other vehicle, Lordship, race and negligence, the driving of other vehicle. There is entire materials is there in the record, Lordship. So we being the non-offending vehicle are not liable to pay compensation.
What was the direction by the tribunal?
To give the awarded amount by the present appellant, Lordship.
100%.
Yes, yes.
This is an injury case.
Yes.
You pay 50%.
50% we are ready to deposit, Lordship.
You take 50%.
So our prayer is, Lordship, release may not be. Because this is their evidence. They are saying that due to the race and negligence of the other vehicle, the accident took place. They have not said that the vehicle driven by the victim is responsible. Entire evidence is that the other vehicle is responsible. We are ready to deposit, Lordship, release, Lordship, to decide.
Whether records have been received?
No, Lordship.
MEC case. Okay, heard me in MA, in main appeal. Heard Mr. A.J. Sakya, learned counsel for the appellant. Also heard Mr. What is your name?
Yes, Talukdar.
This item number?
43.
Heard Mr. S. Talukdar appearing on behalf of Mr. A. Sakya, learned counsel for respondent number 1. It appears from office note dated. You have not taken steps against respondent number 2.
That he expired, Lordship.
So substitution is not required.
No, Lord. There are orders, Lord.
It appears from office note dated 12/5/2026 that the notice issued to respondent number 3 and 4 by speed post have not yet returned. Notices issued have not yet returned. The registry is directed to place the postal track consignment report of the notices issued to respondent number 3 and 4 before this court on the next date fixed. It also appears that the records of MSC case number 1612/2006 has also not been received. Registry to issue reminder for the said records from the concerned tribunal. List this matter again on 26th of June. In IA, heard Mr. A.J. Sekalan and counsel for the applicant. Also heard Mr. What is your name?
S.
Talukdar, appearing on behalf of Mr. A. Sekalan, who submits that the conducting counsel for the respondent number 1 has some difficulty today, though the respondent number 1 has already filed a written objection. Stop. Against the prayer for the written objection against the prayer for grant of stay of the Bakijai proceedings. Stop. Considering the submissions made by learned counsel for respondent number 1, this interlocutory application shall be heard on the next date fixed. Till then, the interim stay granted earlier shall continue till next date. List the matter again on 26th of June. Let him come.
Number 44. Governor.
This IA has been filed for direction to the tribunal. What has happened is that I'm the claimant, Manoj. The claimant filed the accompanying MSc appeal for enhancement of the awarded amount. Now, in that, once the appeal was admitted, Manoj, the records, the PCR has come here. My lords, I am unable to withdraw the awarded amount from the tribunal because the record has come here. So, my lords, either way, either there or let the awarded amount be transmitted here, because there is no other challenge to the award as such by the insurance. The appeal was admitted.
No, we'll issue direction to release the amount. Who is appearing for the other side?
Look, in the main appeal.
Main appeal sound?
No, Malod,
Ramesh.
steps were taken, Malod, on 3/6/25, but there is no appearance.
Lord Mr. A. Ganguly, learned counsel for the appellant. On perusal of the office note dated 27/11/2025, it appears that the records of MEC case number 527 572, no, MEC case number 110/2022 within bracket D has been received from the concerned tribunal. It also appears that notice issued to respondent number 3 has also been duly served. However, the service report in respect of notice issued to respondent number 1 and 2 have not yet been received. The appellant is directed to take fresh steps.
Would your lordships consider waiving notice on the appeal on 1 and 2 because they were proceeded ex parte in the judgment?
1 and 2 X.
Yes. The owner and the rival,
Okay.
and since it is only a quantum issue, so perhaps their presence is not necessary.
Learned counsel for the appellant submits that since respondent number 3, which is the insurance company involved, since notice issued to respondent number 3 has been duly served, and since the respondent number 1 and 2 did not appear before the motor accident claims tribunal also, and the MAC case number 1110/2022 proceeded ex parte against them, notice to them in this appeal may also be waived, as their presence may not be required for adjudication of the instant appeal. Prayer is allowed. The notice to respondent number 2 and 3 is hereby waived. 1 and 2 is hereby waived. This appeal is therefore ready for hearing. Let this appeal be listed again 20th of August in IA Debo, heard Mr. A. Ganguly, learned counsel for the applicant. This interlocutory application has been filed by the applicant / appellant in connection with the connected MAC appeal number 201/2025. Praying for issuance of a direction to the Motor Accident Claims Tribunal, Sonitpur, for release of the awarded amount, which has already been deposited. It has been deposited, which has already been deposited by the insurance company before the said tribunal. Learned counsel for the applicant submits that since in the connected MAC appeal number 201/2025, the records of the MAC case number
110
110/2022 were requisition, and since the record has been already received by this court, the Motor Accident Claims Tribunal, Sonitpur, is reluctant to release the awarded amount to the present applicant / claimant. He submits that since the dispute and since the issue before this court in the connected appeal only as regards the contention of the present appellant regarding enhancement of the awarded amount, enhancement of the compensation awarded to the present applicant. The money, the amount of compensation already awarded need not to be withheld with the Motor Accident Claims Tribunal during the pendency of this appeal. Hence, he prays for issuance of a direction to the concerned Motor Accident Claims Tribunal to release the same. The submissions made by learned counsel for the applicant seems to be reasonable, since in the connected appeal, the issue is only regard the prayer for issue involved is as to whether the claim for enhancement made by the enhancement of the award made by the present applicant is justified or not. However, since as regards the money already, as regards the compensation which has already been awarded by the Motor Accident Claims Tribunal to the what is the to the present applicant. Hence, there is no reason for withholding the same by the Motor Accident Claims Tribunal Sonitpur. The Motor Accident Claims Tribunal Sonitpur is accordingly directed to disburse the amount of compensation awarded to the, how much it is?
No, Lordship will kindly have page 21, my lords, of the MSc appeal minute, the appeal paper book.
Ramesh, appeal memos.
The operative part.
How much has been deposited?
One of the award along with the interest.
Can you explain last name? Present applicant / claimant, that is rupees 10,13,000 along with the interest at the rate of 7.5% per annum, which has already been deposited by the respondent number 3 insurance company before it. While disbursing the said amount, the Motor Accident Claims Tribunal Sonitpur shall maintain some record so that after disposal of the connected appeal, maintain some record and send a report to this court as regards disbursal of the said amount to the present applicant, namely Srimati Sunita Devi Nimodia. This interlocutory application is accordingly disposed of.
Deeply.
Claim number 45.
May it please your lordship. In this case, one IA has been filed for condonation of lordship delay of 199 days in preparing the review application. In this case, what happened, lordship, the predecessor of the present petitioners, one Abdul Rashid Khan,
was defendant in a suit which was filed by the present respondent for specific performance of contract.
Yes.
In fact, he was a tenant under Abdul Rashid Khan. So he filed the suit for specific performance of contract of the suit shop house along with the vacant land, Lordship. As per plain that there was an agreement with Abdul Rashid Khan. Thereafter, Lordship, when Abdul Rashid Khan died from January 2022, he did not pay any rent to the present petitioners. So when they, Lordship, inquired, then they came to know that out of a suit, Lordship, he already entitled for a decree and he already executed the decree in favor of him. So he is the owner of the plot of land. Then
Who is the owner?
the present respondent. Earlier, he was a tenant.
Satra Kumar Das.
Yes.
Okay.
Earlier, he was a tenant under Abdul Rashid Khan. But after death of Abdul Rashid Khan, when he did not pay the rent amount to the legal heirs, then they inquired. Then he said, I have already become a owner of this plot of land by way of a decree, and the decree was executed in my favor. Then the legal heirs inquired and they came to know that from the suit there was a notice served to the predecessor, which was received by one Rafiqul Islam as brother of the defendant. But in fact, there was no brother of Rashid Khan Lordship as named as Rafiqul Islam. So the court proceeded ex parte and the decree was granted in favor of the present respondent. The Lordship proceeded.
Filed the suit for specific performance.
The tenant, present respondent.
Satra Kumar Das.
Satra Kumar Das.
Okay, okay.
The court did not examine the process server, but proceeded ex parte to decide the suit, and accordingly the suit was decreed. And thereafter, one title execution was filed, that is title execution case number 2/2019, page 5, paragraph 4. As per record, Lordship, from this execution case, late Rashid Khan received notice, and thereafter he engaged one advocate, namely Shahanur Sikdar, on 18/2/2019. That Shahanur Sikdar on 18/2/2019 filed some petition praying for time to file written objection, and thereafter on subsequently on 3 dates he remained absent. So the executing court proceeded and sale deed was registered and thereafter disposed of on satisfaction, that title execution case. But that was also not within the knowledge of the petitioners, as their predecessor received a notice as per record, Lordship. Thereafter, the petitioners filed an Order 9 Rule 13 application along with a miscase for condonation of delay. That condonation of delay is Mijje case number 88/2022. That was allowed by the learned trial court, which was challenged by this present respondent by way of CRP, Lordship. That was allowed by your Lordship judgment. That CRP was also proceeded ex parte, as because after receiving notice.
CRP was allowed here.
Yes, Lordship.
It proceeded ex parte.
Lordship, notice we received, we engaged one advocate that we have already stated, Rafiqul Islam, and he stated that case is going on, you need not to worry. So we remained silent, Lordship. Thereafter, this CRP was allowed, where there was none appears for the respondent. And that Rafiqul Islam did not file any wakalatnama. Thereafter, when we inquired, we came to know that CRP was already disposed of. Then we filed an application before Bar Council of Assam. That also I have stated, and Rafiqul Islam returned back the fees which he has received. Those bank statements we have annexed, Annexure A, page 12 to 14. Bank statement, Annexure A and B, page 12, your Lordship will find.
What it indicates?
It indicates that Rafiqul Islam returned the fees which we have already paid to him for attending.
Fees.
Fees, your Lordship.
Okay.
Lordship will find page 12 from last 15/11/24, Rafiqul Islam returned 7,000.
This is the fees which he has.
Yes.
Okay.
Some more also, Lordship, page 14 also from bottom, second one, 19/8/2025, he returned 10,000. We also paid 2-3 installments in, he also returned like that, Lordship. It one, this one, this one.
Now, why now delay has?
Delay, Lordship, when we filed the Bar Council complaint, thereafter we filed this delay application, Lordship, along with the review petition.
No, what is the reason for delay?
Delay, Lordship, we came to know only after disposal of the CRP.
When you came to know? What is the date?
Lordship. Paragraph 7, last paragraph. Lordship. That on last 19/8/2025, the applicants along with younger brother of the applicant number 1 visited the chamber of the engaged counsel and transferred rupees 10,000 of remaining balance fees. The applicants asked their engaged counsel about case number of the case, but the counsel did not provide the same. Rather, they were sent back by saying he will provide the final order copy soon. The younger brother Abaidur Rahman of applicant number 1 somehow collected the case number of the case, and on being checked online, the brother of the applicant.
Okay. When you checked, what is the date when it came to your notice?
That date is not mentioned, Lordship. Only
That is relevant.
after 19/8/25 we checked. So we already came to know that 2/4/25 the review CRP was disposed of. Paragraph 8, Your Lordship, that after getting information about disposed of the case, the applicants along with the younger brother Abaidur Rahman of applicant number 1 visited to the chamber of the engaged counsel and asked about the case status. In reply, the engaged counsel asked the applicants to pay rupees 20,000 for the purported arrangements for drive away respondent and his associates from the applicant's premises and rupees 50,000 for proposed appeal before the Honorable Supreme Court. The applicants immediately handed over the order copy dated 2/4/25 to engaged counsel, and in turn engaged counsel told the applicants that he will do the needful. In this regard, due to some argument took place between them, following repeated demand, the engaged counsel returned the brief of the case along with rupees 6,000 on 12/10/2025, rupees 5,000 on 21/10/2025, and lastly, rupees 3,000 on 28/10/2025 through online to the account number of the younger brother of the applicant number 1. The applicants beg to state that due to non-filing submission of Wakalatnama in the aforesaid CRP IO 157/2024, the Honorable High Court was pleased to dispose of the matter against the applicants. The engaged counsel showing him as legal consultant and a big signboard is installed in front of his chamber in the name and style legal consultant with phone numbers to attract the innocent litigants in the name of providing legal assistance, but practically cheated the innocent litigants. And in this way, the engaged counsel cheated the applicants. So those were stated, Lordship, that due to the said act of professional misconduct, fraud, and deceit, the applicants were unrepresented before this honorable court in CRP IO number so-and-so, for which disposed of the matter against the applicants on the facts and circumstances of the applicants became victim in the proceedings, being no option and fraud of the engaged counsel, who neither submitted wakalatnama nor appeared on their behalf before the Honorable High Court as reflected in the impugned order. Accordingly, the applicants filed a complaint before the Bar Council of Assam, Nagaland, Mizoram, and Arunachal Pradesh, praying for taking necessary action. That the applicant beg to state that on the facts and circumstances filed the instant review petition on 17/11/25. The Bar Council application I have enclosed. Complaint petition, that is page 19. 3/11/25. dated 3/11/25, we have already filed, and the required fees also filed, rupees 1,000. Now, Lordship, in Bar Council, there is no committee due to the election. So the matter was not proceeded, but we have filed complaint against this said advocate. And the condonation was allowed on the ground that our predecessor received execution proceeding notice. Even then, he did not appear before the learned executive court. And moreover, he did not appear to contest the suit. And in fact, Lordship, from the suit, there was no notice received by as per record, it was received by Rafiqul Islam, Lordship. And in fact, there was no Rafiqul Islam in our family. And
that is regarding the notice
from the trial court.
trial court.
Yes.
But in before this court,
This court we have received. We accepted that, Lordship, and we have returned the CRP copies to our engaged counsel, Lordship, to contest the case. We have already handed over all the copies to him to contest the case. And normally, Lordship, as there is the decisions of this Supreme Court says, Lordship, normally a liberal approach may be taken.
no, I'll take liberal approach.
Lordship.
But before that, you have to show why in this review petition has been filed delayedly. You came to know, you met your counsel on 19/8/2025. 19/8/2025. The order was
They have collected all the
the
documents.
so delay was in pursuing the complaint against the
Yes.
council before
We
the
have
bar.
collected all the documents, bank statements, and then we filed the complaint. And thereafter only the condonation application was filed.
Ramesh. Yes, Mr. Singh.
There is serious objections, Lordship.
May please, your Lordship. My lord, the conduct of the petitioner is very important, my lord.
I am taking a short break. Yes, Mr. Singh.
May please, your Lordship. My lord, the conduct of the petitioner is very important, my lord. And in your IA, they have stated in paragraph 4 that the notice of the execution proceeding was received by the original defendant. So they have the knowledge, and my lord, in the execution proceeding, notice was served to them. My lord, Annexer E, page 38 is the notice. Yes, notice along with my lord, possessor report at page 39-40. It was received by the original defendant A.R. Khan. Then, my lord, then again, there was another notice dated 13/8/2019. It was also served on them, and there is a process server report at page 42. I visited the Lordship got it, my lord, at page 42. Vernacular person.
This is notice
in the execution proceeding.
Before the execution.
Yes, my lord. I visited the address mentioned in the notice on so-and-so, met with the respondent, requested him to receive the notice issued in his name, but he stated that he would not receive the notice on that day, and also told me that he would receive the notice if I come again on Monday. Thereafter, again, I met the respondent on Monday and informed of the notice, but they said that he would not accept it. Thus, I returned the notice as I could not be able to serve the same on 2 days of occasions. At that time, the witness who put the signature on the top was present there. So, notice second execution proceeding, the notice was not received. Then, my lord, there was, after the disposal of this
CRP filed by us. The order was placed before the trial court, and the trial court has taken up the case on 4/6/2025. Lord, you will find the order of the trial court at page 50. My lord, this document is very important.
Page.
Page 50. My lord, it is an order after disposal of our CRP. Order dated 4/6/2025. Midjay case number 83 to 25 in title suit. It is their miss case, my lord. The petitioner and OP are represented. Learned counsel for the OP decree holder has filed certified copy of the order dated 2/4/2025, passed by the Honorable Gauhati High Court in CRB IO 157/2024. Peruse the order whereby the Honorable High Court has been pleased to set aside and quash the order dated 5/2/2024 in Ms. J case number 58/2022, passed by this court, and also held that this instant Ms. J case number so and so is barred by limitation. In view of the order of the Honorable Gauhati High Court, this instant Ms. J case is dismissed as being barred by limitation. So, my lord, this is the order pursuant to order of this honorable court, and they have represented while the order was passed. How they can say that?
Who represented?
My lord, their counsel represented.
Who?
OP are represented. Applicant.
No, who was that counsel?
My lord, petitioner and OP. Petitioner means.
No, that is okay. But who was representing who was the counsel? The counsel.
My lord, in the trial court counsel, my lord. They have the counsel.
Against whom they have filed it?
My lord, after order of this honorable court in the CRP, we filed a petition along with the copy of the order. Then the matter was taken up. The Ms. J case number 83/2023 was taken up in connection with the title suit 2126, and while this order was passed, both the sides were represented by the present petitioner as well as the my lord, the respondent our side.
So your submission is that on 4/6/25 they came to know.
They should know.
They came to know.
Yes, my lord. My lord, regarding this order, they have not whispered at all in their review petition or in the condemnation petition. They have not whispered, not challenged this word. Their petition is review petition is.
No, review petition we are not going now. We are only concerned with the delayed condemnation.
Yes, my lord. Yes, my lord. For that, my lord, the date of knowledge. We are harping on the date of knowledge. They are suppressing this fact, and they are, my lord, in their petition, in paragraph 7, they have said they have not mentioned on which day they could know, and they are saying that somehow collected the case number. The notice was served in Dosti copy, usual service, registered post, my lord. So, my lord, they are required to be collect the number. Somehow, this statement is a false. It is not only vague but also a false statement, and they have not challenged in the review petition. My lord. So, my lord, this is a false statement. So, and they in paragraph 8 of the petition, my lord, in paragraph 7, they have stated that on 19/8/2025, they have approached the engaged counsel, and they could somehow collect the copy case number, and they have totally failed to mention the date when they have came to know about the order, and there is no
my lord, explanation, the delay is more than 90 days. Oh, sorry, according 199 days delay, and they have not explained from which date they are to explain, for which part they have to explain in what manner. Totally vague petition. This petition cannot be entertained. And they have also suppressed so many facts, and they have made so many misleading statements so far relating to the date of knowledge, and they are blaming the lawyer, filed the complaint, but without furnishing the copy of the receipt, only petition copy, whether it is against this connection or what connection is not discernible. And the statement of repayment of the fees by that council is also irrelevant in this case. So, my lord, this type of condemnation petition is to be dismissed, not to be allowed, my lord. In fact, they have the knowledge on 4/6, but they are saying that they have contacted with the lawyer on 19/8, but they have actually, they have, on what date they came to know, they unable to make any statement, my lord. My lord, I have some judgment to rely on, my lord.
On which point?
My lord, my lord, my lord, the first case.
No, on which point you are reading?
My lord, first point is that my lord, they are to make statements and date-wise explanation. In that has been pointed out, my lord, in Ramlal, Motilal, and Sotalal versus Reva Oilfield Limited. Paragraph 7 and 8 is relevant, but 8 is sufficient, my lord. Here, my lord. My lord, the middle person, my lord, in the 10 line, in view of the period of limitation, lordship, in middle part, my lord, in view of the period of limitation prescribed, the party would be entitled to take its time and to file the appeal on any day during the said period, and so prima facie it appears unreasonable that when delay has been made by the party in filing the appeal, it should be called upon to explain its conduct during the whole period of limitation prescribed. In your opinion, it would be immaterial and irrelevant to invoke general consideration of diligence of parties in construing the words section 5. The context seems to suggest that within such period means within the period which ends the last day of limitation prescribed. The last day they have failed, that last day, why they have failed last day, that should be explained. That is the view, my lord. In other words,
No.
My lord.
Last day is the period of limit. 30th day.
Yes, well, 30th day.
30th day is the day within which they should have filed.
File.
Thereafter, delay starts. Thereafter, they have to explain.
There is no such explanation, my lord, in their petition. My lord. That is our point. That may very inevitably mean that the party will have to show sufficient cause not only for not filing the appeal on the last day, but to explain the delay made thereafter day by day.
Yes, after last day.
Yes, my lord. They have to explain after last day by day. They have to explain. That is the point here.
In other words, in showing sufficient cause for condoning the delay, the party may be called upon to explain.
Their case is that they were pursuing their complaint against the earlier engaged lawyer.
Mhm.
Therefore, they could not file the review.
That is also apparently false, because they knows that the order, they should know about the High Court's order on 4/6 when the trial court has passed order. They are represented in that case.
Yes.
So that statement is false, man. Only they have filed complaint against the lawyer only to make out a case. That they are unable to make out a case. This is, my lord, one point, and other case, my lord, in Lanka Venkateswaralu by LRS versus the state of Andhra Pradesh and others. Here, my lord, regarding the liberal approach and reasonableness. Paragraph 22 is relevant, my lord. 22 here. No, it is under paragraph 21. It is under paragraph 21, sub-para 22, 25, and 26. It is under paragraph 21, sub-para 22, 25, 26. May I read, my lord?
Yes, what you want to show?
The concept of liberal approach and reasonableness in exercise of discretion by the courts in condoning the delay have been again stated by this court in the case of Balawan Singh Supra as follows. Sub-para 25. We may state that even if the term sufficient cause has to receive liberal construction, it must squarely fall within the concept of reasonable time and proper conduct of the party concerned. The purpose of introducing liberal construction normally is to introduce the concept of reasonableness as it is understood in its general connotation. 26. The law of limitation is a substantive law and has definite consequences on the right and obligation of party to arise. These principles should be adhered to and applied appropriately depending on the facts.
Ms. Chaudhary, you will reply to this 4/6. Yes. Yes. Next week on any date. Next Friday. Okay, this Friday.
Delivery of judgment.
Judgment in item number 1, 6, 7, 8, and 9 will be delivered tomorrow. 1, 6, 7, 8, and 9. 2 matok.
Item number 2.
For reasons mentioned in the judgment, this second appeal is dismissed.
Item number 3 and 4.
For reasons mentioned in the judgment, the impugned judgment of First Appellate Court is not interfered with, and it is upheld, and both the revision petitions are dismissed.
Item number 5.
For reasons mentioned in the judgment, the appeal is allowed, and the Judgment of the tribunal is set aside. I have made certain observation. You may go through it regarding relief, where the relief lies, but appeal is allowed.
Then number 45 continuing.
No?
I know.
Yes, of disposal. Yes.
Last page paragraph. 42, but 42 subparagraph 4 is sufficient. Even said that the appellate is guilty of the provision under the day of adverse position, which has no consequence. Depending on relation, it would mark the process in granting leave to a party of deliberately introducing irrelevant and uncredible case, responsible for taking by judicial.
Now, why are you citing this judgment?
Here, after seeing some facts.
That they came to know on 4/6.
Yes, madam.
Only that's.
Yes, madam. Subparagraph 4 of paragraph 42 is relevant. Once the court discovers falsehood, concealment, distortion, obstruction, or confusion in biddings and documents, the court should in addition to full restitution, impose appropriate cost. And there is suppression of that.
Okay. Yes, Ms. Chaudhary, any reply?
Lordship. That petition, as per their statement, Lordship. Paragraph 10, Lordship, page 34. That the applicants also misled this honorable court by suppressing vital facts. The order dated 5/2/2024 passed in CRP IO number 157 of 2024 was submitted before the learned court of civil judge senior division Gwalpara along with the petition dated 4/6.
Where are you reading?
Paragraph 10, page 34 of the affidavit.
Oh, yes, yes. Yes.
So was submitted before the learned court of civil judge senior division Gwalpara along with the petition dated 4/6/2025 in Ms. J case number 83/2022, wherein the applicants are petitioners. That is a wrong statement, Lordship. Applicants, Lordship, we are the applicants and the petitioners in that application is Annexure 1, page 47. That petition was filed by the decree holder, Lordship. The appointed advocate for the opposite party decree holder begs to state as follows. That the opposite party, namely Chhatrakumar Das, instituted the title suit number.
But on 4/6, you were represented by your counsel.
I am my counsel, Lordship, that the applicants were not there. Thereafter they
But
came.
then that means on 4/6, you came to know about the.
Lordship, normally, Lordship, in civil court, the everyday presence of the clients is not required.
No, but
So even
your
if-
knowledge can be.
Yes, as my, it's counsel.
Counsel appeared.
Appeared, Lordship. So on 4/6, that is prior to coming to the Gauhati, Lordship. So in my petition, I have stated that on so and so, I came to Gauhati. Page 8.
But you have remained silent about 4/6.
Lordship, that was not informed as because that was not written in the petition and there was nothing, Lordship, mentioned about 4/6 order, Lordship. Only we have stated that we have approached the engaged counsel before the Honorable High Court. So when the learned trial court said that already CRP was disposed, Lordship, then it was, maybe it was not immediately informed to the client, Lordship, but it can be considered as it is within our knowledge, Lordship. as my learned counsel was representing. But we have mentioned that on last 19/8/2025, the applicants along with younger brother of the applicant number 1 visited the chamber of the engaged counsel and transferred rupees 10,000 of remaining balance fees. The applicants asked their engaged counsel about case number of the case, but the counsel did not provide the same. Rather, they were sent back by saying he will provide the final order copy soon. So, Lordship, at that relevant point of also, Lordship, the engaged counsel was giving assurance that he will provide the certified copy. In fact, by that time, CRP was already disposed of. So it is not false that we have paid some amount to Rafiqul Islam and Lordship.
Who was the counsel before the executing court? Your Rafiqul Islam.
He is from Gauhati High Court.
Okay. Who was he?
In the first appellate court.
Before the executing court?
Before the executing court, Shahanur, engaged by my predecessor. And at present also he is first appeal was filed by whom, Lordship? That is from the CRP condonation application we can see. Mintu Ahmed, Lordship, before the first appellate court. Miss J case 83/2022 was filed by Mintu.
That means on 4/6.
Mintu Ahmed is aware about.
25, you were aware about. You were aware about the.
My counsel represented.
Yes.
At the High Court was open in yeah. So only this much, the 4/6, which was within our knowledge, and we stated that on 19/8 we came to Gauhati. And my learned friend has stated that on each and every day's Lordship, delay must be explained. There are lots of judgment here, Lordship is aware. On each and every day's delay is not required, Lordship. It is the normal procedure to explain the delay sufficiently, whether the cause was sufficient or not. And here in this case, in my view, Lordship, the cause which the applicant shown were sufficient grounds to interfere with the review petition. And on merit point, Lordship, had it been a case that the petition applicants were represented before your Lordship in CRPIO, your Lordship would have not allowed the CRPIO as because Lordship, there are judgments of this court and Honorable Supreme Court that when trial court exercise discretionary power in revisional jurisdiction, that may not be interfered. And Balakrishnan is also, Lordship, on the same footing and on the same law, Lordship. This Honorable Court already allowed one CRP where condonation was allowed in along with the title appeal, and that condonation allowance order was challenged before this Honorable High Court, and our High Court says that in revisional jurisdiction, we cannot interfere with the discretionary power of the learned trial court. So had it been a case that Lordship CRPIO was.
Where is the order which is under review?
In review petition. Page 13.
Ramesh, review petition. Page
13. I will start from page 14. The legal heirs filed Order 9 Rule 13 petition along with a condonation application. That condonation application was allowed by the learned trial court. Against that order, the CRP IO was filed.
Heard.
May I place the judgment?
Yes, give them.
Lordship, in Pradeep Kalita, relying on N. Balakrishnan, the CRP was dismissed. And Prakash Sesam. N. Balakrishnan, I am relying for the decision, paragraph 10 to 14. N. Balakrishnan, 1998, 7 SCC. Page 1 to 3, paragraph 10, 11, 12, 13, 14. The reason for such a difference tense is thus the primary function
Why are you relying this?
on the ground of condonation of delay that limitation is not for to destroy the rights of the parties, Lordship.
Okay.
And
Para?
para 10, 11, 12, 13, 14. And may I read the last paragraph, paragraph 14?
Yes.
In this case, explanation for the delay set up by the appellant was found satisfactory to the trial court in the exercise of its discretion, and the High Court went wrong in upsetting the finding, more so when the High Court was exercising divisional jurisdiction. Nonetheless, the respondent must be compensated, particularly because the appellant has secured a sum of rupees 50,000 from the delinquent advocate through the Consumer Dispute Resolution Forum. So here it says that if the discretionary power was exercised by the learned trial court, normally the High Court should not interfere under revisional jurisdiction, Lordship. So my argument of point is that, Lordship, if the CRP IO was contested by the guest counsel, your Lordship would have not interfered with the discretionary power of the learned trial.
Okay.
That opportunity may be granted to the applicants. And this Prakash Sesamal, Lordship, Jain, 1998, 9 SCC, page 718. Paragraph 5. Having regard to the fact that the High Court had accepted the unconditional apology tendered by the advocate on record in the matter of his adding a prayer for condonation of delay in the memo of appeal, after it had been filed, we are of the opinion that the High Court should not have dismissed the appeal. As a result of the dismissal of the appeal, the appellant who had no role has been made to suffer on account of a fault on the part of the advocate, in respect of which the court has accepted the unconditional apology of the advocate. So in my case, Lordship, due to the fault of advocate, the applicant should not suffer. For that, I am relying on this. And on N. Balakrishnan, relying on N. Balakrishnan, CRP 182, 2017. It was already reported in NEJ, Lordship. NEJ to NEJ direct likha ase. NEJ to citation ke diye.
No, suppose your condonation petition is allowed, then do you have ground for review? On what ground you are seeking review?
Lordship, review had it been contested by the applicants, Lordship.
No, that is not a ground.
Lordship.
You must have specific ground for review.
Sure, our case is that the delay was sufficiently explained before the learned trial court.
That will amount to argument on merits. You must have some independent ground. In Pradeep Kalita, which para you are relying?
Pradeep Kalita, Lordship, that is page 3. I have considered the submissions advanced at the bar and have also perused the materials brought on record. I relied N. Balakrishnan, that already I have submitted. last paragraph, your lordship may see, the power under section 5 of the Limitation Act 1963 is a discretionary power, and it is for the court to record a satisfaction as to whether the explanation furnished by the applicant is sufficient to condone the delay or not. Once a view has been taken by the court in exercise of such discretionary power, the revisional court would not disrupt the finding of the lower court.
But it will help you in only if the delay is condoned in this
Yes,
case.
that is the merit of the
But-
review, lordship. And that too, lordship, they have filed the CRP under 227. So far, my understanding, lordship, that would have been preferred under section 115, as condonation was already disposed.
No, whether review is maintainable,
Yes, lordship.
what are the grounds?
Page 6 of my review petition, lordship.
What is the ground? Because
That the
that's,
process server was not examined by the learned trial court while deciding the suit. That point was not
that also touches on the merit.
merit.
On what ground review can be preferred is
Error and-
statutorily recognized.
The thing that the merit of the case was not projected by the engaged counsel, as he was absent on the day of hearing of the CRP.
Okay. Heard Miss R. Chaudhary, London Senior Counsel, assisted by Mr. A. Amin. A.M. Amin, Learned Counsel for the applicant. Also Mr. S.A. A.R. Sikdar, Learned Counsel for the respondent.
I would refer one.
Let this matter be listed for delivery of orders on 18th, Thursday, on 18th.
Obliged, lordship.
Jikiman. No, next Thursday, Kiman. 20.
21. This Thursday is 21, next is
21.
28. Next, this Thursday is 21.
21. 21.
Highly obliged.
Point of
Mark.
Yes, sir. Whether review can be entertained as an original hearing. Then the release comes. It cannot be reopened as an original hearing. And there should be apparent error on the report.
Obliged, lordship. Very serious objections, lordship.
To separate file out Rakibu. Chamber of Demo. Criminal matter Anut Mathima legs.
We'll wait.
Let me finish the
Verification is there.
let me finish the criminal matter. For only one matter is there.
Standing at 10, 40 and 41.
Yes. Yes. What is your submission?
The client will inform me that his file is going on an official job. And petitioner's family member engaged counsel for filing. Other than still counsel has filed a bail petition before the High Court. That was not aware. Therefore,
No, but in High Court, both the bail applications were by your father.
he could not understand that the bail is filing High Court early. Because sign was taken, the ticket fact was signed. But the illiterate person could not
No, but it was the duty of the council to make him understand. There is apparent breach of the notification and which amounts to suppression of fact, material facts.
because it did not disclose that while subsequent bail was filed. The the council also did not understand. Because when father come with all documents were not generally, every advocate will believe that yes.
Lordship, it can be easy, FIR number easily can be checked whether any bail application is pending or not in the website of the Honorable High Court Lordship. It can be easily checked.
But in every case, we don't check it because a person come with the report. Why I will check? If something is doubt, then we can. In every case, we cannot check it.
Heard Miss D. Ghosh, Leonard. Which is the item? You have filed your wakalatnama. Heard Miss D. Ghosh, learned counsel for the applicant. Also heard Mr. K. Das, learned additional public prosecutor, as well as Mr. N. Uddin, appearing for respondent number 2. This interlocutory application has been filed by the applicant/informant in connection with bail application number 2401/2025, praying for cancellation of bail granted to the respondent number 2. Respondent number 2. On the ground that in the bail application filed by the bail application to leave. Two 2401. The bail application which was filed by the respondent number 2, which was registered as bail application number 2401/2025. The fact of pendency of an earlier bail application in this in connection with the same case, that is Sessions Special Case number 21/2025, arising out of Nunmati PS case number 226/2024 under section 64 of BNS, read with section 6 of POCSO Act, was pending, has not been disclosed. Ms. D. Ghosh, learned counsel for the applicant, submits that the applicant herein is the who is the applicant?
Mother of the victim.
Is the mother of the
Informant. is the-
mother of the victim girl, as well as the informant informant of the affair, on the basis of which Nunmati PS case number 226/2024 was registered. She submits that by order dated 25/9/2025, the respondent number 2 was granted bail by this court in connection with Sessions Special Case number 21/2025, arising out of Nunmati PS case number 2226/2024. However, in the bail application filed in the said case, the supporting affidavit, which was sworn by one Rupsan Ali, who is the father of the present respondent number 2, nothing was disclosed regarding the pendency of an earlier bail application filed by the present respondent number 2, which was registered as bail application number 2029/2025. She submits that where is the notification?
Notification is at page lordship, page 22 lordship.
She submits that the notification number 27 issued by the registry of this court on 3rd of May 2025 clearly mandates that in case of subsequent bail application preferred by the same accused in same affair, no, this notification is
There is another one notification also.
this is not the relevant notification.
There is another one notification.
Where is that?
That is with rejection, but that with declaration has to be made that no bail case is pending before this,
That is the relevant notification.
pending before this on the court.
Due. I'll dictate it in chamber. Cancelling the bail. I'll dictate the remaining part in chamber. The bail granted to the respondent number 2 in bail application number 2401 is hereby cancelled. You go through the detailed order later on. I'll give the time. Okay. Since this cancellation is on technical ground, it will not debar you from praying for fresh bail before the trial court. trial court will consider on its own merit. That observation will be there. Wait. Go through the order later on. Okay, next item.
Standing item 13.
May please, yes, my lord.
If you.
This first appeal against order is preferred, my lord, assailing the order whereby my application for injunction was rejected, my lord. Before I go into the impugn order, my lord, I'll just put the facts of the case, my lord. The predecessor interest of the present petitioner's appellant, my lord, he was the owner in respect of a plot of land, measuring, my lord, 5 bigha 9 lessers. Subsequently, my lord, that land was acquired by the government, that is the present respondents, in respect of 1 bigha 4 kothas of land. And after acquiring and after transferring of 1 bigha 3 kothas of land, 3 lessers of land, the predecessor interest of the present appellants, he remained a plot of land measuring 1 bigha 3 kotha 9 lessers remained with him, my lord. So that 1 bigha 3 kotha 9 lessa is the present suit land. Now, my lord, in the plaint, my lord, I have specifically pleaded that my case is that, my lord, I am the owner in respect of the aforesaid land on the basis of inheritance. And
1 bigha 3 kotha
9 lessers. So, my lord, my specific case was that the present appellants, they being the legal heirs of Abdul Haq, they inherited the plot of land on the basis of inheritance, and thereafter they were possessing the suit land till 2025. On 26/1/2025, they were dispossessed by the respondent number 3, 4, and 5. That is the government authorities, without following any due process of law, my lord. On receipt of summons, my lord, the respondents appeared, and only respondent number 5, they filed a written statement, admitting my right title interest and also admitting that only a plot of land measuring 1 bigha 4 kotha of land was acquired by the government way back in the year 1969. And they have in fact also admitted in paragraph number 11 of their written statement that they have trespassed into the suit land. Now, along with the plaint, I also filed an application for under order 39 rule 1 and 2, seeking a prayer for injunction. The impugn order, my lord, will find at page number 98, annexure 11.
Yes.
Order dated 23/2/2026. Both sides are represented. Today is posted for order in this missed case, which is registered on the basis of an application filed by the plaintiff petitioners under Order 39 Rule 1 and 2, read with Section 151 of the CPC, seeking temporary injunction restraining the opposite parties, their man, agents, officials from raising any multi-storied building or structure over the suit land described in Schedule A by demolishing the old Assam type house standing there, and also restraining them from transferring, alienating, granting allotment of the suit land in favor of any third party or government body till disposal of the suit. The contentions of the plaintiffs, shown of unnecessary detail, is that the predecessors of the petitioners, namely Abdul Haq, was the absolute owner of the suit land measuring 1 bigha 2 kotha 17.7 lessers covered by DAG number 512 old 2806 2869 new of KP Patta number 3 old 102 2662 new of Revenue Village, Borhoza under Muza Beltola in the district of Kamrup Metro, Assam, along with Assam type house and other structures standing thereon, which is described in Schedule A of the petition. The petitioner stated that
in whose possession the land is presently?
Presently with the respondent number 345, my lord. That is, my lord, the Department of Water Resources.
And what was the injunction which you sought?
I sought for, my lord, that they should not construct any multi-story building over the land, demolishing my old Assam type structures, and not to alienate or allot the said land to any third party, my lord.
What is this present status? Any attempt of construction?
They are trying to construct, my lord.
Trying means?
Trying, my lord, they materials have been there, materials they are accumulating, my lord. And so I have every apprehension that on the basis of those materials, they may raise a construction matter because they've already demolished the Assam type structures.
Oh, today is the, yes, what is your submission?
Therefore,
You are not in position.
it can well be compensated, my lord, if they finally come out the issue. It can be compensated. Therefore, there is a question of redemption as such at this point of time. And besides that, my lord, if I may take your lordship, what my friend was saying, unnecessary details. Actually, what has happened? What they are saying that there is a portion of land, a part of it which was sold off by the predecessor and interest of the plain citizens. And then part of it has been acquired by the government of Assam. And thereafter, a dispute arose in the year 2024. Matter was, it is also been narrated in the place as well as in this appellate memo. In 2024, there was a dispute and the matter was thereafter been referred for demarcation of boundaries to the circle officer. After factual verification, a report was submitted by the circle officer that it doesn't belong to their application was rejected. Now, my lord, while filing a suit, now they have asked for recovery of past possession. But my lord, this order, as passed by the circle officer, has not put under challenge. So this order, which ought to have been either, I'm not to advise my friends, but it ought to have been challenged before the new authorities. And even if they have filed a suit thereafter, they have stated all these facts that these were dismissed. And then these have not been challenged. So it remains in force now. And now we are in position and we are trying to, we are going to construct a building over the plot of land. Since 1969, the land is in our possession. It has also been admitted by them. And
Since 1969.
I'm forwarding you the copy of.
No, but their case is that they were dispossessed on 26, 24 January.
Let me kindly come to page number 62, madam. It will clear the matter. 62 page number. Madam, they are in position.
No, today we'll admit the appeal.
Madam, just one thing, madam, because of the interim period, that is why, madam. Just
What interim period?
interim period, madam, injunction is at least status quo may be maintained, madam. Because they are also not going to be prejudice in any manner, status quo, madam. Because they are going to construct, that is why I'm telling you.
No, whether records would be necessary for deciding this.
Can copies may be called for, madam, with regard to documents?
No, we will go through the injunction order. Your ground, the injunction was refused because balance of convenience was not found in.
And irreparable loss. Prima facie.
That was not found. You justify from the.
That's why, my lord, may kindly come to page number 62, my lord. My specific case is that, my lord, they trespassing in the Suitland in the month of January 2026, my lord. Page number 62, my lord, may kindly come to, my lord. Page number 62. Para 18 of the written statement. Para 18, if my lord takes, this paragraph was not at all considered, my lord. Para 18, that the statements made in paragraph number 11 of the plain, the answering defendant number 5 begs to state that in the last part of May 2024, the officials of the defendant number 325 illegally encroached some portion of the land of the Suitland from his southwestern boundary by taking advantage of his establishment.
The respondent is only government.
Government, only government. Government has taken the property, my lord. I do agree, my lord, since 1967, they are in possession of the land, but through that acquisition process, only 1 bigha of land was acquired. Now they are trying to take over the complete land, my lord, the whole land, whole plot of land measuring about 2 bigha, 2 kothas, my lord. They have admitted also in paragraph 18, my lord, that they have illegally trespassed into the Suitland. If they have, they are in illegal possession of the Suitland, my lord, why their illegal possession should be benefited? Why they should get the benefit, my lord? It is my own land, my lord, having right title interest that I inherited from my predecessor interest. Let status quo be maintained, my lord. Thereafter, my lord may call for the records and matter may be heard and disposed of, my lord. Within 2 weeks, my lord. Otherwise, my lord, if they go on and if they allot the land to some other department, then it will lead to multiplicity of proceedings.
There
my
is
lord.
no question of allotment.
They have admitted, my lord, illegally they have trespassing to the suit land, my lord.
Copy this.
We are admitting the appeal, calling for the records.
At
On
least
next date, we'll decide.
status quo, at least, my lord, in the statement.
There seems to
This
be
is
some-
specific, my lord.
some manipulation, madam. The original, this statement we had filed. This doesn't tally with this. Paragraph 360.
This is what I have been given. That's why, my lord, let record be come.
Whose written statement is there? Is this at page 62?
This is, my lord, defendant number 5. Only defendant number 5, as per my information. But even it is there, my lord.
There is no police case also.
But in fact, we have lost.
This was in 2024.
We have lost FIR also, my lord, that we have filed.
But- Mr. A. Iqbal, learned counsel for the appellant. Also, Miss P. Chakravarti. Your government counsel. Standing counsel. Learned standing counsel. Water resource development. What is the department?
What?
Water resource this department of the government of Assam, appearing for respondent number, all appearing for respondent number 4 and 5. And Miss Burman is appearing for respondent number 1, 4, and 5. Miss D.D. Burman, learned additional senior government counsel, appearing for respondent number 2 and who is appearing for 3, 2 and 6. Got to 1, 3, 4, and 5. Stop. This appeal under Order 43, Rule 1R of the Code of Civil Procedure 1908 has been filed by the appellants impugning the order dated 23/2/2026 passed by the Court of Learned Civil Judge Senior Division number 1, Kamrup Metro, in Ms. J case number 349/2025 arising out of title suit number 247/2025, whereby the prayer for grant of temporary injunction by the present appellant was rejected by the trial court. I have gone through the grounds stated in memo of appeal and have considered the submissions made by learned counsel for the appellants. This appeal is admitted. Let the scanned copy of the records of Ms. J case number 349/2025 as well as that of title suit number 247/2025 be called for from the trial court. The registry to issue and take steps for requisitioning the scanned records of the scanned copy of the aforesaid records. Let this June 2nd week, Ramesh, June 2nd week. Let this case be
10th of June.
let this case be listed on 11th of June. 11th of Thursday,
Thursday.
11th of June. Since all the respondents have already been represented by their engaged counsel, no formal notice need to be sent to the respondents. On arrival of the scanned copy of the records, endeavor shall be made to dispose of this matter on the next date fixed. List accordingly. And at this stage, we are not giving any interim relief.
Matter number 46.
Make this also. Not in this appeal, my lord. Services completed, my lord. PCR has also been received. So my only prayer is that my lord, matter may be fixed for admission hearing, my lord. Can be disposed of at the stage of admission itself.
Admission stage,
Yes, ma'am.
but it is already admitted.
Yes.
So it will
Or
not come in
Date may be fixed, ma'am, for hearing.
for hearing.
Yes, date may.
Heard Mr. S. Das, learned counsel for the appellant. Also heard Ms. S. Paul, appearing for the respondent. It appears that on perusal of the records, it appears that this appeal is ready for hearing. It will go in the month of August. Let this
July.
July, it will be difficult. Let this matter be listed
25th of August.
on 25th of August.
Any date. Before 25th of August.
Let it be on 25th of August.
Order.
Okay, 4th of August.
Highly obliged.
Number 47 and 48.
My lord, item number 47, this is a review application for recall the order dated 11/3/2026 against the IA civil number 262/2025, my lord.
What is the ground for review?
My lord, ground is that, my lord, this honorable court had dismissed my delay condone petition in respect of filing the MSc appeals, filing number 5422/2025, my lord. So there are some grounds, my lord, which are not mentioned in the delay condone petition. That grounds is also mentioned, newly grounds is also mentioned in the review application, my lord. So your notice may be issued to the opposite party, my lord.
Heard Mr. B.R. Das, learned counsel for the review petitioner. This review petition has been filed by the applicant seeking review of the order dated 8/1/2026 passed by this court in IA civil number 262/2025, whereby the prayer for condonation of delay in preferring the connected MAC appeal was rejected. Issue notice to the respondents. The applicant shall take steps for issuance of notice upon the respondents by speed post as well.
My lord, respondent number 2 and 3 is not required, as the in delay condone petition, the notice was served to them and they did not appear, my lord.
No, review petition, you have to issue notice to all the respondents.
highly authorized. My lord.
Speed post as well as by usual mode within 7 days from the date of this order, returnable on 24th June.
Item 49.
My lord, item 49 is also the same review application against
Amita, you will order out. Same order,
same one.
only the order under review will be different. यहाँ से देख लेना. Same order.
Same date, my lord.
Yes, 24/6.
Item number
Highly
2.
Please, madam. As per the office note, lordship, AD card not returned yet, lordship, and LCR also not received, lordship.
Heard Mr. P.J. Burman, Learned Counsel for the
Appellant.
appellant. On perusal of the office note dated
7/4/20.
7/4/2026, it appears that service report in respect of notices issued to the respondents is awaited. Moreover, the records of the MAC case number 146/2020 have also not been received. Stop. Issue reminder for the records, aforesaid records, registry to issue reminder. Registry shall also place the
Track report.
postal track consignment report of the notices issued to the respondents by speed post before this court on the next date fixed. Let this matter be listed again on 27 June.
Highly authorized.
Item 51.
Lordship, as per official dated 14/5, a service report may be awaited, Lordship.
Heard Mr. A.J. Sakya, Learned Counsel for the appellant. On perusal of the office note dated 14/5/2026, it appears that service report of notices, but you have not taken by speed post.
We have taken note.
It is by usual post, normal post.
Usual process also taken.
But there is no indication that you have taken in the office note. Service report is awaited. The appellant is directed to take fresh steps for issuance of notice upon the respondents by speed post also within 7 days from the date of this order, returnable on
13 July.
13 July.
Item 52.
May I plead your lordship?
Yes.
Lordship, earlier we have taken the steps, but due to some defect, it was not shown in the record. Lordship, we have clarified the defect today.
Heard Miss, what is your name?
Lordship, I'm M. Das, appearing on behalf of SK Media.
Miss M. Das, appearing on behalf of Mr. S.K. Methi, Learned Counsel for the appellant. Though office note dated 14/5/2026 shows that no steps for issuance of notice upon respondents has been taken by the appellant. However, Learned Counsel for the appellant submits that the appellant has taken these steps for issuance of notice today only. As such, the service report of the notices issued to respondents may be awaited. Let this matter be listed after 2 weeks on a date to be fixed by the list.
Item 53.
In this case also, Lordship, service report may be awaited, Lordship.
Not Mr. A.J. Saikal, learned counsel for the appellant. Office note dated 14/5/2026 shows that the service report in respect of the notices issued to respondents have not yet been received. Stop. Learned. Stop. The registry is directed to place the postal track consignment report of notices issued to the respondents by speed post before this court on the next date fixed. Let this matter be listed. 26th June.
Lordship, in respect of item number 51, Lordship, that was the, we had not taken step. Actually, we had taken step, Lordship, on 15th. So there is some delay. We have got that copy. On 15th, we have already taken in the item number 51.
What was the order?
It was directed to take fresh step on the respondent through speed post. But
When have you taken steps?
15th, Lordship, some delay was there on our part.
Okay.
On 15th, we have to.
Change कर दियो. 15,
15.
51 दियो. What was the order? No. Service report is awaited. Mr. A.J. Saikal, learned counsel for appellant, has submitted that the appellant has taken steps for issuance of notice upon respondent by speed post only on 15th of May 2026, and hence he prays for directing the registry to place the postal track consignment report on the next date fixed. Registry shall do so. Let this matter be listed on, what was the date? 13th of July.
Item number 54.
May peruse the last order.
Yes.
In regards to the order dated 27/3/2026, the opposite party were to file an objection for grant of stay.
No, what happened in the main appeal?
That was admitted, Your Lordship, but it was not stayed, as my senior submission was to deposit the amount received under the conventional heads. They were to file an objection for the same.
You'll be filing objection. Okay. Okay. In main appeal,
So we're ready to deposit the amount under the conventional heads. They may go
no,
for
just a minute. We are taking up the appeal first. In make appeal. Heard Mr. S. Sharma, learned counsel for the appellant. Also heard Mr. A. Agarwala, learned counsel for the claimant respondent.
Lordship, may peruse the office note dated 14/5/2026.
On perusal of the office note dated 14/5/2026, it appears that service report in respect of notices issued to respondent number 5 and 6 have not yet been received. The registry is directed to place the postal track consignment report of notices issued to respondent number 5 and 6 by speed post before this court on the next date fixed. Let this matter be listed on
22nd of July.
22nd July. I do. Heard Mr. S. Sharma, learned counsel for the applicant. Also heard Mr. A. Agarwala, additional learned counsel for the respondent slash claimant. What was the
Lordship may consider the submissions made by my senior on the last occasion and stay the application, stay the proceeding. We were ready to deposit the amount under the.
now you deposit 50%?
Lordship, the deceased was a government employee, and as per notification dated 14 September.
You will be filing objection. Okay. Though the counsel for the applicant has submitted that the applicant insurance company is ready to deposit the compensation awarded against conventional heads. However, as the deceased was a government servant, the applicant is reluctant to agree to the condition of depositing 50% of the awarded amount. On this, learned counsel for the claimant respondent submits that some time may be granted to claimant respondent to file a written objection against the application for stay filed by the applicant. The prayer is allowed. Let this matter be listed again on 27 July. On next date, you file.
They may go for execution. The short date may be given.
You will be going. Sure. June or last week. 26 June. 26 June. In both.
I think 55.
Maybe the lordship, I have for the lordship modification of the order lordship.
What modification?
The lordship, the interim order was lordship recall. The order dated lordship is 20 lordship.
Page?
Page 20 lordship and except 5 lordship.
Yes, what is the
The lordship, the area amount was not and the regularly not paid the maintenance lordship. Then the honorable court has the recall the interim order lordship. The letter or he paid the area amount regularly lordship. The award amount lordship the 4,000 and the interim is the honorable court has the 3,000.
Now what do you want?
The earlier order, the 3,000 is lordship.
No.
Page lordship 8 lordship.
Page?
8 interim order. Relevant portion lordship the 9 lordship.
What happened to the main criminal revision petition? We'll hear the revision. Now, how much you are paying?
The lordship that feel that the next date lordship, the lordship in the IA is annex the order lordship. Lordship the page 22 onwards lordship. On 27/11/2025 lordship 3,000 page and lordship the order dated page lordship 24 29/11/2025 lordship order. This order is not paid lordship. 9/12/2025 lordship. He paid the 16,000.
What was the order? Which order has been impugned in the revision?
In IA lordship.
Not in IA.
Lordship the page 29 lordship.
Ramesh, revision. Which page?
4,000.
No, the records have been received now.
Receipt lordship.
We'll decide the matter.
The lordship I pay the
No.
lordship the.
Heard Mr. H.
Announcement.
I heard Mr. N. Ahmed, learned counsel for the applicant. Also heard Mr. H. A. Ahmed, learned counsel for the respondent. This interlocutory application has been filed for modifying the order dated 6/11/2025 passed by this court in criminal revision petition number 46/2025, whereby the stay granted upon the execution of the order impugned in the connected criminal revision petition number 46/2025 was vacated as the applicant has failed to pay the interim maintenance amount of rupees 3,000 to the respondent in terms of the directions of this court. Now, what is your ground why you are seeking?
The lordship the later on he paid the area maintenance lordship.
Learned counsel for the applicant
They
submits that later on the applicant has paid the area maintenance amount to the respondent. However, learned counsel for the respondent submits that in the meanwhile, the records of the trial court have already been received and the applicant has yet to deposit an area amount of about rupees 30,000 to the respondent. Considering the submissions made by learned counsel for the respondent and after going through the records, this court is reluctant to make any modification of the order dated 6/11/2025. More so as the trial court record has already been received and same is ready and the connected criminal revision petition is ready for hearing. This interlocutory application is therefore dismissed. In criminal petition heard both Mr. M. Rahman, learned counsel for the petitioner, also heard Mr. H. A. Ahmed, learned counsel for the respondent. The scan copy of the record, I say,
He said, yes,
records of the trial court have already been received. Hence, this revision petition is ready for hearing. Let this revision be listed for hearing.
28 Lordship. This one, Lordship.
When?
28
Of?
May.
No. Let this matter be listed on 4th of August.
Lordship, the earlier date, Lordship.
We don't have dates. 4th of August. In the meanwhile, you pay. Next item.
56.
May Premier, as per office note dated 13/5, service on respond number 1 and 3 is complete. Two, my lord, address is not found, not known.
This is a condonation application.
Yes,
Who is to?
2 is the owner.
Okay, then you have to take steps.
My lord, it's regarding quantum, the appeal. So he may be struck off.
You are insurance company.
Yes. We have filed his appeal.
Heard Mr. A. Bhattacharya, learned counsel for the applicant. On perusal of the office note dated 13/5/2026, it appears that notice issued to respondent number 1 and 3 have been duly served on them, whereas notice issued to respondent number 2 could not be served. Learned counsel for the applicant submits that since the applicant insurance company has filed the connected appeal, mainly aggrieved with the quantum of compensation awarded to the claimant. Hence, he submits that presence of respondent number 2 may not be necessary for adjudicating the connected appeal. He therefore submits that the notice to respondent number 2 may be waived in this interlocutory application. The prayer is allowed. We will give one shot.
My lord.
Sometime.
Yes.
Let this matter be listed again on 2nd week of June. In the 2nd week of June on a date to be fixed by registry.
Lovely.
Article 57.
There was office note dated 13/5/2026. The respondent number 1 and 2 are served. Your Lord.
How many more respondents are
Respondent
there?
3, the addressee could not be found. It was received by one of the relatives for respondent number 3. Victim 5.
Who is 3?
Three is the driver.
What is your submission?
What should I condone the delay of 190?
No, regarding notice.
Is, it may be waived off and may be condoned today. As respondent 1 and 2 are already served.
What for you have filed the appeal?
This
What
case,
ground?
this case proceeded ex parte against us, Lord. An award of rupees 7,72,000 was awarded. Lordship may peruse page number.
You failed to appear before the tribunal. Now, what is your contention before this court?
Lordship may
Heard Mr. S. Sharma,
from page 5.
learned counsel for the applicant. On perusal of the office note dated 13/5/2026, it appears that notice issued to respondent number 1 and 2 have been duly served, whereas notice issued to respondent number 3 could not be served. Learned counsel, whether before the tribunal 3 had appeared?
Yes, Your Honor.
Learned counsel for the applicant has submitted that the notice to respondent number 3 may be waived as is no, you take okay. क्या लिखा last? Sternus waived. However, on perusal of the office note, it appears that notices issued to the said respondent by speed post have been delivered to him as per the postal track consignment report annexed along with the record. Accordingly, the notice issued to said respondent is held to be duly served. This application under Section 5 of the Limitation Act has been filed by the applicant insurance company, praying for condonation of delay of 198 days in preferring the connected appeal, wherein the applicant has impugned the judgment and award dated 14/11/2024 passed by the Motor Accident Claims Tribunal, come the Court of London Additional District Judge Bishwanath in MSC case number 41/2018. London, where are the reasons?
Paragraph number 3, starting from page 5.
London counsel for the applicant has submitted that the applicant have stated the grounds for delay in preferring the connected appeal in paragraph number 3 and 4 of the instant interlocutory application. So I have gone through the same grounds. Considering the grounds stated in paragraph number 3 and 4 of the instant interlocutory application to be sufficient cause which prevented the applicant in preferring the connected appeal within the prescribed period of limitation, the delay of 198 days in preferring the connected appeal is hereby condoned, and this interlocutory application is allowed. The registry is directed to register the connected MAC appeal and list the same for admission after a week on a date to be fixed by it.
Make the Lordship. Lordship, as per office note dated 13/5/26, respondent number 1 refused to accept notice, may be deemed to have been served. And respondent 3 and 4 entered appearance. So far as 2 and 5 are concerned, no ID card, no unsubmitted notice has been issued.
2 and 5 will ask postal track consignment. Heard Mr. M. Talukdar.
Lordship, their service may be waived.
No, no. No more waiving. Learned counsel, heard Mr. M. Talukdar, learned counsel for the applicant. Also heard Mr. A.J. Sakya, appearing for respondent number 3 and 4. Appearing for respondent number 3. You are also heard Miss D. Goswami, appearing for respondent number 4. On perusal of the office note dated 13/5/2026, it appears that the respondent number 1 has refused to accept the notice. Hence, the said notice is held to be duly served on him. As regards respondent number 2 and 5, service report is awaited. Stop. The registry is directed to place the postal track consignment report of notices issued to respondent number 2 and 5 by speed post before this court on the next 8 weeks. Let this matter be listed on 13th of July.
59.
May I please, Your Lordship. This is an application for condonation of delay in preparing the review application. First time this is listed. Notice may go, Your Lordship.
Heard Mr. A.R. Shom, learned counsel for the applicant. This application under Section 5 of Limitation Act has been preferred by the applicant for condoning the delay of 123 days in preferring the connected review application. Let the notice be issued to the respondents. The applicant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 15 days of date of this order, within 7 days of the date of this order, returnable on
15 July.
15 July. Since Ms. D.D. Burman, learned additional senior government counsel, has appeared for respondent number 8, 11, and 12, no formal notice need to be issued to the said respondent. However, you have received the copy. However,
supply.
requisite numbers of the copies of the instant interlocutory application along with the annexures will be supplied to the learned senior additional government counsel. Let this matter be listed again on 15th of July.
Oblige, Your Lordship.
Item number 61.
May I please, Your Lordship? I for condonation of delay of 215 days, Lordship, preparing this appeal, Lordship.
And Ms. R.B. Bora, learned legal aid counsel. This interlocutory application has been filed by the applicant Preeti Singha, no, by the applicant Nam Nindiko, applicant under Section 5 of the Limitation Act 1963, praying for condonation of delay of 215 days in filing the connected matrimonial appeal. Let the notice be issued to the respondent. The applicant shall take steps for issuance of notice upon the respondent by speed post as well as by usual mode within 7 days from the date of this order, returnable
15 July.
on 15 July.
Lordship, another connected IA is for stay of the
After service of notice.
diplomatic.
Item 62.
May please your lordship. In this IA, there is a delay of 30 days and it is for the first time.
Ms. D. Goswami, learned counsel for the applicant. This interlocutory application has been filed by the applicant insurance company, praying for condonation of delay of 30 days in preferring the connected miscellaneous first appeal. Issue notice to the respondents. The applicant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days of the date of this order, returnable on
15 July.
15th of July.
Obliged.
Supplementary item number 65.
Right, please, your lordship. My lord, in this case, as per office note dated 15/5/26, service is complete, lordship, 1 to 4. Regarding response number 5, lordship, there is no reflection that it's served. As lordship, in the Wakalatnama, they have filed, and cause list also name of Mr. F.A. Hassan is their lordship. They have filed Wakalatnama in delay petition, lordship. Name is shown in the cause list. Five, no? That's one number 5. All the claimants 1 to 4 is Rajarsi Day.
Who is 5?
The 5 is the lordship owner of the vehicle. And you are appearing.
Is for claimants, all the claimants. There are 4 claimants.
And owner?
But in the lordship, in the IA petition, they have filed Wakalatnama. Name is shown as F.A. Hassan for respond number 5. Wakalatnama, I think their lordship. In IA number 4273/17.
IA has been disposed of.
Disposed of. Delay was condoned.
Delay condoned.
Delay was condoned.
You are appearing for, Mr. Hassan is appearing for 5 also. Take instruction. Heard Ms. M. Chaudhary, learned counsel for the appellant. Mr. T. Sheikh appears for Mr. F.A. Hassan, learned counsel for respondent number 1 to 4. Ms. M. Chaudhary, learned counsel for the appellant, points out that in the connected interlocutory application, which has already been disposed of, Mr. Hassan has also appeared for respondent number 5, that is the owner of the offending vehicle. On this, Mr. Sheikh sought some time to seek instruction in this regard. Stop. Mr. Hassan may clarify on the next date as to whether he has been engaged for respondent number 5 also. Let this matter be
17 June.
listed on 17 June.
Most obliged.
Item number 66 and 67.
My lord, in item number 66, my lord, 1, 2, 3, and 7 is appeared, my lord. 6 is appeared, my lord. We have to take steps on respond number 4, 5, and 7, my lord. 5 is expired, my lord. It may be struck off, my lord, and then, my lord, we have.
Who is 5?
5 is driver, my lord. He is not necessary party.
What is your insurance company?
Yes, my lord.
What is your appeal? What is your case?
Lord, 2 vehicles are involved in, my lord, one accident, my lord. So responsibility of contributing negligence, my lord, responsibility 50/50, my lord.
Heard Miss L. Sharma, learned counsel for the appellant. Also heard Miss R.D. Majumdar, learned counsel for respondent number 6. learned counsel for the,
Thank you.
again 7,
7 and 4 and 7, my lord, only.
learned counsel for the appellant submits that some time may be granted for taking fresh steps for issuance of notice upon respondent number 4 and 7. She submits that as regards respondent number 5 is concerned, he has already expired and the
It is already struck off in item number 67, my lord.
he has already expired.
It's struck
So
off.
appeal will automatically abate against him, even if it
Yes.
is not struck. Okay, you want striking off.
Yes, ma'am.
Already expired. However, since considering the issue involved in this appeal, the presence of, she submits that the presence of the driver of the which vehicle,
AS23E3123.
driver of vehicle bearing number AS23E3123 may not be required. Hence, his name may be strike out from the memo of appeal. Stop. Same is done. The prayer is allowed. However, same is done at the risk of the appellant. Stop. The appellant is directed to take fresh steps for issuance of notice upon respondent number 4 and 7 within 7 days from the date of this order by speed post as well as by usual mode, returnable on
17 July.
17 July. The appellant is also directed to furnish memo of appeal along with annexation, furnish a copy of memo of appeal along with annexation to the learned counsel for respondent number 6 within 2 days from the date of this order. List accordingly.
Obliged.
Item number 68.
May I please, your lordship? This ISA bill for early hearings of chief.
Early means it will go to August. Okay. Heard Mr. R.
Yes, sir.
Mr. A. Sharma, learned counsel for the applicant. Also heard Mr. S. Sharma, learned counsel for the respondent insurance company. This interlocutory application has been filed by the applicant. Your insurance company, applicant claimant paying for expeditious hearing of the connected MAC appeal number 71/2023. The prayer is not opposed to by the learned counsel for the insurance company, hence same is allowed. Let the connected MAC appeal be listed for final hearing on 4th of August. This interlocutory application is accordingly disposed of.
Right.